The Royal Commission into Defence and Veteran Suicide is now in session. Please be seated.
Good morning, Mr. Everybody.
Good morning, Commissioners. This morning we will hear from two lived experience witnesses, and then after the luncheon adjournment we'll hear from a panel of two experts on the question of Australia's regime for veterans' compensation and benefits. Prior to coming to those witnesses, might I first attend to a housekeeping matter, and that is to correct something on the transcript. So on day 24, page 2191, line 31, there is a reference to an item 8 that was tendered. That in fact should be an item 9.
Okay, thank you.
You'll now hear from a lived experience witness, Ms. Teresa Pine. I call Ms. Pine. She will be via video link.
Teresa Pine, do you swear by Almighty God that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Ms. Pine, have you made a witness statement in this Royal Commission?
Yes, I have.
Commissioners, there are two forms of that witness statement. First, there is a confidential and unredacted form of the statement, which is available only to you for the benefit of the transcript only. The statement's document code is TPY.0000.0001.0001. Secondly, there is an unredacted version of that statement, which will be made available to the public, subject always to the non-publication order that you have made. And the document number for that statement is TPY.0000.0001.0001_R. Ms. Pine, do you have your statement with you?
Yes, I do.
Ms. Pine, do you wish to make a correction to that statement?
I do.
And is that correction in paragraph 6?
Yes, it is.
And what is the correction you wish to make?
It mentions May 1967, and it should be May 1969 for the second tour of Vietnam.
Thank you very much. And having made that correction, is your witness statement true and correct to the best of your knowledge and belief?
Yes, it is.
Commissioners, I tender that statement.
Thank you will be accepted and just allocated the next consecutive number.
Thank you. Ms. Pine, in today's evidence, I'm not going to be identifying your relatives by name, and I would ask that you do the same. If you do not wish to answer any question, a particular question, that is okay. Please indicate as much, and I will move on. Do you understand those points?
Yes, I do.
And Ms. Pine, does the evidence you will give today concern most particularly your father, a Vietnam veteran who was diagnosed with PTSD?
Yes, it does.
And does your evidence also concern the impact of your father's PTSD on your father, your mother, yourself, and your family more broadly?
Yes, it does.
I should mention for the benefit of the public that some of Ms. Pine's evidence might be distressing. And in that regard, Ms. Pine, if at any point you require a break, please do let me know and that can be arranged.
Okay, I will. Thank you.
Coming then to your witness statement, Ms. Pine, might you describe a little about your family and some background?
I am one of 2 living children to a Vietnam veteran and his wife. There were 7 pregnancies for our parents, with 4 girls being born. Our elder sister was born in March 1963 and died 3 months later. My older sister was born in 1965. She's still here with me, alive. I was born in 1968, and our younger sister was born in 1972 and died at the age of 15 and a half years.
And your father was a Vietnam veteran, you mentioned. Do you know when he served?
Yes, so he served in Vietnam twice, so May 1966 to June 1967, and then again in May 1969 to June 1970.
And just for the timeline, how old were you when your father served in Vietnam?
My older sister was 10 months old when he left the first time and 22 months old when he came back. And then the second tour, I was 10 months old and 22 months old when he came back.
Thank you, Ms. Pine. Did your mother describe to you their life prior to your father's going to Vietnam?
Yes, she did. Our mother often talked of our father being a loving father and husband before going to Vietnam the first time, and how on return after 6th Battalion was in the Battle of Long Tan, he had changed. She talked about the excessive drinking and smoking and the cost of these habits.
And what did you observe of your father as you were growing up?
There was however, we did live with Dad and his alcoholism and heavy smoking. Saw him grumpy in the mornings after he'd had nightmares and not enough sleep, and lived with the results of the high spending.
And what was your recollection of your father when he was not drinking?
He was a good dad. When he wasn't drinking, he did his best to be a good husband and a good father.
And might you describe to the commissioners the supports that were available to your family when you were growing up?
There was nothing available at all to our family. And that's between 1968 and 1980, to help us deal with Dad's issues and the effects of those issues on us. It was left to our mother to manage whilst she cared for her veteran father, who was ill, and 3 young children, one of which was disabled.
And Ms. Pine, might you be able to indicate the impacts on you in particular as you were growing up? And if you want, I can come back to that question.
I've lost. Sorry, yeah, I've lost where I'm at.
That's right.
So
I can come back to that question, Ms. Pine. And I'll return now to your father's service in Vietnam. Did your father share with you his experiences?
yes, he did share some of them.
And might you be in a position to share those with us?
Yeah. Our father served 2 tours of Vietnam with 6th Battalion. He was in Charlie Company on the first tour, which was the 66-67 period, when the Battle of Long Tan was fought. Our father told me that on the first deployment to Vietnam in 1966, that on the 18th of August, Charlie Company had been out on patrol during the night, and Delta Company went in to exchange places with Charlie Company. Our dad told me that Charlie Company was ready to go out and help Delta Company when the battle began, but were held back by higher ups. Dad told me that Charlie Company went out to the rubber plantation on the 19th of August in APCs to help locate their mates' remains and bring them back to base. This took a huge toll on our father, seeing his mates dead. I've heard a number of Dad's Charlie Company friends say how hard it was to continue in Vietnam and when they came home, because not everyone came home. They lived and others died.
Thank you, Ms. Pine. And did your father ask or tell you about any other aspects of his service?
He did. On our father's return to Australia, he talked about the government determined that only members of 6th Battalion who had feet on the ground in the rubber plantation during the battle would be recognised as part of the Battle of Long Tan. I've heard this a number of times whilst volunteering with the 6th Battalion Association. Our father told me that he and his Charlie Company mates, to whom he spoke, felt they were forgotten and that their mental health didn't matter, and that they as soldiers didn't matter as much as those in Delta, Alpha and Bravo companies to the ADF. Mum and Dad told us there was no counselling help for anyone when the soldiers returned from Vietnam. And in my opinion, this is very wrong and shouldn't happen again.
And tell me, how did it, are you able to say from your observation how these events impacted upon your father?
It put a further strain on Dad's mental health. By the time we moved to Singapore, which was 1970, our father was an alcoholic and smoked very heavily. And this was his way of dealing with the undiagnosed PTSD. These behaviours impacted our family in many ways. We didn't have much money for food, and Mum made our clothes.
And were there other life events that further impacted your father and your family?
There were. Our family posted to Singapore in October 1970 with 6th Battalion. Our little sister was born in November of 1972 while we were living there. She was a normal baby until about 6 months old when she got a high temperature. And after this, she stopped crawling, stopped rolling over, and just lay there. And no doctors in Singapore could tell my parents why. After Dad's deployment in Singapore, on the 31st of October 1973, we returned to Brisbane to live. We lived at Ashgrove with Pop, our mother's father, and lived through the 1974 floods with 6 foot of water through the house, and our belongings still in storage, Army paid storage, went under sewage and were all lost. By the end of 1974, our little sister had been diagnosed with muscular atrophy and given only 2 years to live. Our parents' mental health was affected by this news.
And might you, from your observation, explain the way in which this affected your father in particular for the moment?
Our father's behaviours got worse at this point, and he also began chronic spending, where he would spend money buying vehicles and selling vehicles and things, and Mum started working nights to offset the spending.
And that is true then also of the impacts, the exacerbating impacts of your younger sister's disability. Did it exacerbate those behaviours?
It did. As mentioned, she was diagnosed with muscular atrophy in 1974. Having a disabled child really strained our parents' relationship and put extra pressure on my older sister and myself. Part of the reasons that Dad left in 1980 was the fact our little sister was dying. I took on helping Mum carry the wheelchair up the 14 front stairs. It was an electric wheelchair with 2 motorcycle-sized batteries. In helping look after our little sister, a child in a body that did nothing for itself, with a mind that wanted to learn everything. At times, my older sister and I had our own childhood restricted However, we enjoyed having our little sister home and spending time with her. She spent, from about 1976 onwards, she spent most of her life living at Xavier Hospital for Crippled Children, where she also attended special school. And she came home on weekends and school holidays. When Dad was away on training exercises or travelling for work, there was no army or government assistance available to Mum to help with our little sister. During these times, the 6th Battalion Wives Club rallied to help Mum to bring our sister home for the weekends until I was old enough to help with the wheelchair. If the wives had not done so, our little sister would have been stuck there and unable to come home to visit us.
So, Ms. Pine, I take it from the evidence you've just given that your parents separated when you say your father left?
Yes, they did. They separated in 1980.
And I take it too that you're saying that your mother did not receive any financial support or assistance after the separation.
That's correct. As the ex-wife, she was entitled to nothing from DVA or the Department of Defence.
And might you tell the commissioners now how these events impacted, and the matters you've described have impacted on your mother's health and well-being?
Mum's mental health issues were either caused by or exacerbated by Dad's military service.
And might you explain whether your mother received any counselling through either the Department of Defence or Veterans Affairs? And if so, how that came about?
Yep. She got no counselling through Department of Defence or DVA, but in approximately 2012, I rang VVCS, which is now Open Arms, to ask for counselling for Mum, and was told that as the ex-wife, she was not entitled to anything. Once I explained that Mum's mental health issues, which at the time were mostly undiagnosed, were affecting me, and it stemmed from her time as a military wife, they sought approval to give Mum some counselling. The VVCS counsellor diagnosed Mum as suffering from grief and loss disorder, anxiety and panic disorder, depression and reliant tendencies, so reliant on others, me, to help her through life. When I decided I didn't need the VVCS counselling assistance anymore, they closed my file and cut Mum off from any further counselling, even though her mental illness was getting worse. And then Mum was put into the public system for counselling after that.
And did she obtain counselling when she was put into the public system, as you say?
We did, but that was a bit of a fight as well, just to keep her in the system and to get the sufficient counselling, I think is the right word, because the health system's pretty strained.
Thank you, Ms. Pine. And might you describe any continuing impacts to this day on your family life with your father?
For a long time, my sister and I both have very vivid memories of our childhood, and my sister has told me that she suffers from nightmares from time to time because of things that happened in our childhood as well. Yeah. So, yep.
Are you
that's all.
able to speak to the impacts on you, whether you feel that way? You mentioned you have vivid memories. Does that continues and nightmares?
Yeah, well, I don't have nightmares as such, but I do have vivid memories of things, and I've done a lot of work on myself to help me deal with that. And in that work through process, I then decided that I wanted to, help other people deal with the effects of this sort of thing as well, of PTSD in the family.
And did your father's mental health condition impact on any other aspects of your life? Did it impact, for example, on your education? And if so, how?
It did. As a military kid, you transfer whenever your parents get posted. So we had to readjust every time we got posted somewhere to a new school and make new friends. And for me, I felt that we did lose some continuity in that. and therefore you don't feel that you fit in. Yeah.
And did you receive any assistance or educational support from either of the Departments of Defence or Veterans Affairs as you were moved about?
No, we didn't get any assistance or support. The long tan bursary, which came out a number of years ago, when it was and similar educational support for veterans' children, when it became available, we were all too old. The age brackets that they put on the eligibility, because my sister being born in 1965 and me in 1968, having an age bracket of 35 years, we were already well over 35 when they became available, or when we became aware of them, because none of that support was released for us to know about, even if it was there earlier than that. I'm aware from dealings with veterans that nothing about this has changed. There's still limited information about what educational support there is available and how the families can apply for it.
Thank you, Ms. Pine. And tell me, you've mentioned that your experiences impacted upon your later working life. Might you explain to the commissioners what career choices you made?
Due to all the mental health issues in our family, I chose to work in human resources and as a counsellor or life coach. I hold diplomas in human resources, counselling, business and leadership and management. And I run a holistic business working with people dealing with mental illness, and I provide that life coaching to help them through things and how to deal with the effects of those issues.
And tell me, in your role, Ms. Pine, do you provide services to serving and ex-serving defence members?
Yes, a number of the clients that I have are family members of military and emergency services members, and my experiences help me to help them.
And from your direct experience, do you have anything to tell the commissioners about your observations of veterans' interactions with the departments?
There was a lack of support available to mum to assist her with our younger sister. That still exists today. I have a friend who has 2 children. Their dad is ex-military with PTSD, and the children both have significant health issues. Both of those children are in and out of hospital regularly, and there's been no support from ADF or DVA for my friend or her family. I know several widows of veterans' suicide. They feel forgotten. They feel like their loss doesn't matter to ADF or anyone. They struggle to raise children, sometimes young children, alone when they thought it would be a partnership. I work with Army and RAAF members and their families, and I know that there continues to be a huge reluctance to seek help for mental illness and sometimes physical injuries within members of the military. Members have said that this is because I don't want to be kicked to the curb, I don't want to lose my job, or I don't want people looking at me or treating me differently. When members are reluctant to seek treatment, I observe that it has several impacts. Firstly, the member is not being treated for whatever the illness is. Secondly, members are being reposted on overseas tours without being treated or assessed. And thirdly, the families are struggling with the member adamant they are continuing, even though the family know they are not well enough to do so. This places more and more stress and anxiety on members and their families. The multiple pieces of legislation for individuals to work through when making a claim, the VEA, the MERCA, the CIRCA and Comcare, this makes the claims process complicated and frustrating for claimants and advocates. Many people I've spoken to are angry, depressed, anxious, and reluctant to apply for assistance due to the complicated process and perceived lack of understanding by public servants in determining outcomes, which in turn causes more complications for them and their families. They are reluctant to come forward with health issues, both mental and physical. They believe that the ADF will just kick them to the curb if they are unwell. People putting their hand up for help when feeling unwell, either mentally or physically, is not a reason for someone to be sidelined or kicked to the curb. They need help and they need to feel useful. The length of time taken to assess claims, provide outcomes of claims, and having to deal with DVA staff who did not have experience with the military adds to the anxiety of claimants. DVA staff need to have a knowledge of how the military works, what the 3 services do, how ADF classify operation, and how injury and illness may be caused. This would allow the DVA staff to better understand, discuss, and assess claims. I have a friend who retired after over 40 years Army service, and in discussion, I hear the frustration he felt when dealing with what he called young people not old enough to know about the war telling me what to do and how to feel. I have read most of the medical statements of principles used for claims, and it is very extensive. If the legislation is simplified so that having some injuries or illnesses accepted as allowable, for example, ankle, knee, leg, back injuries for infantry and paratroopers as a result of carrying backpacks or jumping from aircrafts with backpacks weighing in excess of 30 kilos. This would reduce the volume of items needing medical evidence and proof. It would also reduce the strain on the country's medical system too, as GPs and specialists wouldn't have to spend patient time with veterans obtaining proof of injury and illness for DVA claims. Further, if the injury or illness is recorded in the member or ex-member's medical file, why should they have to get assessed and prove it was service-related? Take that away and make it allowable from the Defence medical records. A way to simplify the legislation would be have one act which covers all options in different chapters and appendices, depending on service and operational timeframes. Have one process that applies to all serving and ex-serving members of the 3 services. Have allowable claims for certain fields of work within ADF based on the regular and systemic work requirements of the role. For that same example earlier, jumping from aircrafts and carrying backpacks of over 30 kilos and the injuries that tend to come from that, so knees, ankles, and backs. Remove the difference to entitlements between years of service and operations of service. They all serve one country and one employer, the ADF. There needs to be a review of treatment protocol so that there is more communication between approved specialist providers and GPs. I am aware of circumstances where the communication has not been effective and the member's health has suffered.
Thank you, Ms. Pine. And tell the commissioners, what has your father's and your family's experiences taught you about what veterans and their families might need?
There needs to be support for families of deployed members. There was absolutely no support for the members of 6th Battalion when the members were serving in Vietnam. The wives created their own wives club and helped each other. There needs to be support for families who have disabled children. Mum had nothing like that. When Dad was away, Mum had to rely on the unofficial wives club to help her to transport our sister home for weekends. It is not right that once a couple are separated, the wife, husband or spouse, during the times of deployment, loses all support and any claims through DVA for pensions and medical assistance. This is particularly so when the member has a diagnosed illness that causes strain on the health of their family. Our family suffered because of this.
And Ms. Pine, what comments, if any, do you have about the medical support and treatments that ought to be available to veterans with mental illness and also their families?
There was a lack of support for Mum with our younger sister. I'm aware that with my work with Defence families that there's still a lack of assistance when families have children with disabilities. When disabled children are born to military members, there needs to be recognition that extra support services may be needed when the member is away from home, whether that be postings, overseas deployments or training. And additional support could be offered by way of additional leave if children become unwell for lengthy periods. Legacy does an amazing job trying to support the families who are left behind after a member dies by whether inaction, training, or suicide. But they need more funding and more government support to do this. ADF and DVA also need to have more ability to support these families. It's not just about money, it's also about the mental health of the family and its impact on the lives of children and their lives as they grow. If an ADF member decides to suicide, there is a lack of support and treatment in the system. This cannot continue. Change needs to be made, and acceptance of mental health issues in the military needs to be real and not just talked about. It needs to be genuine concern and help given. There needs to be a form of education support for the children of veterans so that they do not miss out on higher education opportunities.
Is there something further you wish to say, Ms. Pine?
Yes, there is. I am aware from my direct observation within my own family and also the work I have undertaken with other families that the stigma of mental health in the military needs to be addressed, as it is a major factor in the volume of suicides amongst ADF members and ex-members, and the high level of depression, anxiety, and financial strain. White card free access to counselling is a great improvement, although many members do not believe it will not impact their jobs, so many will not access the help that they need. There needs to be a review, as I mentioned, of the treatment protocols so that there is more communication between the specialist treatment providers and the GPs. This will ensure that treatment which is provided to the member is appropriate and not worsening their medical issues. I ask that the square peg, square hole methodology in relation to medical injury and illness stop. Everyone is individual. Everyone reacts differently to similar situations. This is how two people standing side by side in war can be affected differently. One suffers PTSD and the other does not. The human brain and body reacts differently, processes differently. So why are we using an archaic system that wants doctors to assess everyone in the same way against the same outcomes? A new process needs to be developed that better suits the uniqueness of individuals when assessing illness or injury.
Thank you, Ms. Pine. And moving to another topic, do you have any comments at all on transition and the role of families in transitioning?
The transition from the ADF needs to be more about training members back into society, back into owning their emotions and feelings, and teaching them how to treat their family as people and not members of the military. They need to know how to translate their skills from the military to the community. They need to feel that their skills will help them be useful after the ADF. This will alleviate the depression and thoughts of not being useful, not being a real man, and not being able to provide for my family, which are things that can lead to suicidal thoughts. Families, as the support of the members, should be included in all areas of a member's transitioning out of ADF. The family need to understand the process and be provided with some idea of how a member may feel or react to being transitioned out, especially where such transition is on medical grounds and not necessarily something the member wanted. It must include procedures for family to discuss a member's reaction with someone in a position to help that member whilst the transition process occurs. As stated above, people react differently. However, if family members have an idea of the ways members may react, it will prepare them and give them an avenue to raise concerns. I worked for the state government for 28 and a half years in human resources, industrial relations and payroll. My experience has been recognised by previous managers when short-term contract work in recruitment has become available since leaving the public service. I recently participated on a panel for an apprentice intake process for a state government department. There was a high number of applicants who indicated in their applications that they were leaving the military. I noticed that the ADF members were unable to translate their military skills to provide answers or information regarding their suitability for the trade roles available. I could do this as I read applications because I understand both military and public service needs. Other panel members could not do this as they do not have the military knowledge. So these people missed out on interviews and apprenticeships and a way of assimilating back into a non-military life. This part of transitioning out of the military needs improvement. Military skills definitely translate to civilian employment. If a member transitioning out of ADF can claim a civilian job using their military skills, the risk of depression or suicide should reduce significantly. It is obvious to me that ex-members, members and families are struggling when I see the creation of new ESOs and non-government organisations occurring quite frequently. In my opinion, there must be a gap in the system for the need to create these organisations, and they each have a different aim or purpose. If the government were to provide the services needed for members, ex-members and families, then there should not be a need for so many ESOs.
Is there anything more you wish to say on that topic?
There's one more thing. If an officer recommends a member for a medal or recognition, the ADF should award the recognition. It is known in military circles that some of the members who served at Long Tan waited upwards of 25 years for the recognition that they deserved. At our dad's funeral, one of his army mates talked of Dad being put forward for a mentioned in dispatches, or MID, during his second tour of Vietnam for his work in recalculating mortar firing coordinates. The original firing coordinates were based on mortars firing from ground level to the target. In Vietnam, mortars were fired from hillsides to the ground. His MID was knocked back due to the quota already being met. The use of quotas in awarding citations and medals needs to cease. If a member has performed well enough for a higher ranked officer to recommend them for a citation or medal, then the decision should be based on the recommendation alone, not on how many have already been awarded. And in discussions with family, with friends who are partners of ex-military members, I have been told that there have been instances where DVA claims by some members are approved and a monetary payment is made for the suffering and support of children. Not all these payments are used for the children. I've heard where parents are separated and the ex-member has kept these child payments and used them to purchase cars and houses. If this type of payment is to continue and the payment is for the child, these payments need to go into a trust account for each child until they're 18 years old, not paid to the parent. The child, as a young adult, can then make their own decision on how to use the funds, for example, for higher education.
Thank you, Ms. Pine. Now, Ms. Pine, you've spoken to the commissioners about some of the difficulties that you experienced and your father experienced upon your father's return from Vietnam. Are you able to identify positive aspects of growing up as a military child?
Yes, there was lots of positive aspects. So in the mid 2000s, my dad was visiting my house. He stood in front of my library shelf and said, "You have more books on the Vietnam War than I do." And I responded, "That's because you were there and I have to read about it to understand you." From this day forward, our relationship changed. He knew I was interested in what happened to him, and he started to open up and talk about parts of the Vietnam War that I had not heard before. This was when he told me about one of his triggers, death. He didn't talk about dead people at all. This knowledge of his trigger helped explain part of why he left in 1980 and his reaction when my sister died in 1988. I told myself in 1994 it was my time to decide, did I want Dad in my life? And if so, I had to put the effort into the relationship. Because until then, so between 1980 and 1994, the anger just chewed me up. I decided I wanted a relationship with my father, so I put in the hard yards building a relationship I could live with. And in 2013, with more personal healing done, I was able to, for the first time since 1980, to tell my dad I loved him. Was it the same relationship as my friends had with their fathers? No. Was it one I could build and make work? Yes. I visited Dad most Fridays from the day in front of that bookcase to spend time together. In a way, it made up for some of the lost time. When his cancer was diagnosed, I continued to visit, including at the nursing home, every Friday from August 2020 to the day before he died in March 2021. Even though he couldn't talk anymore, he was my dad. He needed me there to support him and love him, and I was.
If you need to take a break, Ms. Pine, we can certainly do that.
Just a quick breath and I'll be good to go. Okay.
We're not in a rush, Ms. Pine. Please take a moment. Take your time.
Yeah. Okay. I've spoken here about our family life and the negative effects of military life on us. Now I want to provide the positive side of being a military child, an army brat. Being a military child has helped me to speak and act with equality, honesty, and integrity. Show respect to elders, those in positions who have earned respect, and to treat everyone the way I want to be treated. Live by my morals and ethics, even when life pushes me to do otherwise. Trust my military brothers and sisters, the other army brats I grew up with, and the lifelong bonds that I have with them. Be dependent and self-reliant. Stand in my own power as a woman in this world. Be driven to improve my life through learning, even when it was a struggle to afford. Have a strong sense of personal responsibility. Stand up and speak out when something isn't right or someone is hurting because they can't speak out. And be proud of those who join the military and do their jobs with honour, integrity, and distinction, no matter how others treat them. I am still learning every day how to ask for help and to know I don't have to do it all on my own, how to let people inside my personal protective barriers, and how to love everything about being the me I am today. In all my life experiences and all my learnt knowledge, I have always felt a strong connection to my Army family and 6th Battalion and the need for a system that defends our country and our way of life. I will continue to support my military family and everyone I interact with in life the best way I can by helping them to release the emotional connection to the hurt and pain of the past and use their energy to move forward on their journey as I progress on mine. We just need to keep working on the system to ensure it does not fail anyone else moving forward. There has been sufficient hurt, pain, and suffering within the wider military family. We need to look after everyone the best we can.
Thank you very much, Ms. Pine. The commissioners may now have some questions for you.
Thank you. Commissioner?
Yes, thank you very much for your testimony. There's a lot in it, I think, about the impact on family, the intergenerational impact, the need for support, and not just historically, but you also referred to contemporary veterans and families, etc. So through the work that you do with your counselling, so it's very relevant. And the suggestions for improvement that you put forward, very helpful. And it was also good to hear the positives, I have to say, that you've articulated very clearly. I just had a couple of questions. One was in relation to the issue of your sister with the disability, and a question about how that was dealt with in terms of the need for postings and relocations versus her need for access to health services?
Yeah, Commissioner, we were based in Brisbane, and I believe that was also part of the reason why Dad left in 1980, because for him to get a promotion, he needed to take a posting, and we needed to stay here in Brisbane with my little sister and her medical team.
Yeah. Okay, so that actually was a very significant issue, albeit that it, in terms of being able to access support for your sister's health needs.
Yes, it was. We were told that she was one in a million, that we probably wouldn't know anybody else with muscular atrophy, but we actually did. But it's at the time it was a rare disorder that not a lot was known about.
And my other question is in relation to VVCS. I mean, from what I understood from what you said was that essentially they sought special permission to be able to give service to your mother as an ex-wife, but it was because you were a child and were had identified a need for services. Is that the correct understanding?
Yes, Commissioner. If her mental health issues weren't affecting me, on top of Dad's mental health issues affecting me, they still would not have given her counselling, because they had to go, from what they said to me, they had to go quite high up within VVCS to get that approval.
And are you aware whether that's still the case in terms of Open Arms today? And I apologise, I'm probably not the right person to ask. I need to ask Open Arms, but...
Yes, Commissioner, as to my knowledge, from discussions with my friends who are ex-members in later parts of service or more current parts of service, once they leave, separate, divorce, they only are entitled to counselling through VVCS for approximately 12 months, and then they cut off.
Okay. Thank you. That's all the questions I had.
Thank you, Commissioner.
Thank you, Commissioner Douglas.
Thank you for your evidence. No, I don't have any further questions. Thank you.
Thank you.
Are there any matters arising?
No, Commissioners.
Ms Pine, I just wanted to thank you for the evidence you've given today. We know it's difficult, but I think Commissioner Brown summed up very well a lot of the really important issues that you've raised that we are considering, and I just want to thank you for coming forward. Thank you.
Thank you, Commissioner.
And might the witness be released from her summons?
Yes. Thank you again, and you're released from the summons to appear today.
Thank you very much, Ms Pine.
If there's nothing else, we'll adjourn.
Short adjournment.
All rise. The Royal Commission will now adjourn until 11:30. The Royal Commission into Defence and Veteran Suicide is now in session. Please be seated.
Yes, good morning, Ms Bridget.
May it please the Commission. On the 11th of February 2022, pursuant to Section 6D, subsection 3 of the Royal Commissions Act 1902, the Commission made a direction in the form of a non-publication direction that certain witnesses not be identified in giving evidence, and subsequently directing that certain witnesses be referred to using a pseudonym. That direction applies to the next witness, Commissioners, and the pseudonym is CB1. Noting this direction, Commissioners, I call witness CB1. The witness can be affirmed.
CB1, do you solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Commissioners, the witness has made, there are two versions of the witness's statement, a redacted and an unredacted statement, and I shall tender those shortly. Witness, you made a statement to the Commission signed and dated 30th March 2022, is that correct?
Yes, I did.
And that statement has 4 annexures, is that correct?
Yes.
Operator, please display WIT.0004.0001.0017_R. Witness, can you see this document in front of you?
Yes.
And do you recognise this as the cover page of your statement?
Yes.
Operator, please turn to 0029 of the document. Witness, there are 13 pages to your statement, is that correct?
Yes.
And are the contents of your statement true and correct?
Yes, they are.
Commissioners, I tender the statement of CB1 signed and dated 30th March 2022 as a public statement exhibit, and that will be the redacted statement.
Thank you. Will be accepted and allocated the next consecutive number.
And I tender the unredacted statement, apologies, Commissioners, as a confidential exhibit.
Similarly accepted and allocated the next.
Witness, are you giving evidence to the Royal Commission today as a person who has personal experiences of your time in the Royal Australian Navy and how these experiences have and are still impacting on your mental health?
Yes, I am.
And are you also giving evidence about your experiences with making a claim to the Department of Veterans Affairs and your experiences with rehabilitation consultants? Is that correct?
Yes, that's correct.
And witness, if at any time you need to take a break, please do let me know and I will ask for an adjournment. And if there are any questions that you do not want to answer, please say so. Witness, you joined the Royal Australian Navy when you were 19 years old, is that correct?
Yes.
And was there any particular reason why you joined the Navy?
I joined the Navy because my parents basically were adamant that I join the Navy. I had lost the job, resigned from a job, and they were wanting me to work, and so I was pretty much forced into it.
And was there anything that you recall about the recruitment process?
Yes, I remember that it was very fast. There was a lot of people there, and I can remember during the psych interview that I was surprised. I wasn't asked a lot of questions in relation to my home life or my past, or it was all very nice and it was quite generic in the questioning, but I just remember it being very fast and pretty frenetic actually.
And did you undergo any initial training when you joined the Navy?
Yes, I was at recruit school in HMAS Cerberus.
And how would you describe your time at recruit school?
Horrific, traumatic. I experienced, I was assaulted, abused during my 3 months of recruit training.
And witness, I'll continue to ask questions, but I've just been informed that your lawyer has not had an opportunity to make an appearance. And Commissioners, I'll just ask now for the witness's lawyer to make that appearance. And my apologies that was not done earlier.
May it please the Commission, my name is Ms Hull, Hull, and I appear for the witness.
Thank you. Appearance noted.
Thank you, witness, for allowing me to have that interruption. And I'll just go back in terms of the question that I asked you was about your time at recruit school, and you said that it was horrific. And would you like to say any more about your time at recruit school?
Basically, I guess I didn't feel safe at recruit school. I was assaulted by my petty officer who was in charge of my squad. And I also experienced harassment by him and other petty officers that were in charge of us. And also experienced some in relation to the other women that I joined up with. So it was a very traumatic and really awful time for me, and I couldn't wait to basically get out of it.
And I won't be asking you any more questions about those traumatic incidences, but can I just check, when you say assaulted and harassed, are you talking about being sexually assaulted and sexually harassed?
Yes, yes.
Thank you, witness. And where were you posted after your training at Cerberus?
After my training at Cerberus, I was posted at HMAS Cuttable in Sydney.
And how would you describe your time at Cuttable?
It was awful too. I had, after what had happened to me in recruit school, I kind of, something had snapped and I just kind of went off the rails quite a fair bit. But I was working 4-day shifts, like 2 days on and 2 days off, so 11-hour days and 13-hour nights. I was shouted at a lot. There was still lots of sexual harassment that continued throughout my time there. It was a daily thing, and I was bullied as well by the chief Ran and the warrant officer that was in charge of us.
And did you say Chief Ran, witness? And
Yeah.
what does RAN stand for?
Yeah. Women's Royal Australian Navy.
And you also said that something snapped and you went off the rails. Would you like to say something more about how you went off the rails?
I was drinking a lot. I was partying. I became very promiscuous and put myself in very dangerous situations that I'm quite surprised.
ask for the usual direction. And witness, I'll just ask that you don't provide any details in terms of any methods. Thank you. And did you seek any assistance at this time when you had that suicide attempt?
No, I was living at the time, I was living in a shared house with other people I worked with, and the girl that lived in the next room, she was there and I showed her what had happened, and we decided not to tell anybody because it was, I just was too scared. I didn't know what would happen to me if I said anything to anybody. I'd never mentioned, nothing that had happened to me previously I had mentioned to anybody because it was just not done, and I was too scared to say anything. So we just dealt with it ourselves.
And can you recall, and it doesn't matter if you can't, but can you recall what that fear was, what you were fearful of?
I was just fearful of the officers and the people above you, and because of the way they treated you like a number and the way that you were so dehumanized, there was no way that you could approach anyone with any issues that you had and feel like that anyone would help you. It was like the culture that you suck it up. You just deal with it. You never cry, you never show emotion. It's just suck it up and deal with it. So that's what I did.
And during your time in the Navy, how would you describe, you mentioned the word culture there, how would you describe the Navy culture?
Oh, it was male dominated. It was, as I said, you were treated like a number. You were treated like a thing, like you just were there to be told what to do it. And that was it. And if you didn't do what you were told, then the consequences could be quite dire. And you just did what you were told. If people shouted at you, if they bullied you, it didn't matter. You just did it. And that was the way it was, and it was quite. There was one example, I guess, was there was a tradition of in bars. I remember at HMAS Cuttable, and I'd also seen something similar at Cerberus, where men would take their pants down and stick toilet paper up their bum and light it, and it was called the Dance of the Flaming Arseholes. And we had to witness this and things like that, where it was just like, I guess it was like living in the Wild West in a movie, where you just honestly, if civilians had walked in and seen that, they would have been absolutely horrified.
Witness, thank you for sharing those details. I know it would not be easy for you to have to recall those incidences. Can I ask you what you mean by dire consequences?
Well, one example, I dyed my hair blonde one day, and I got told when I went back to work that I had to dye it back, that I couldn't do that, and if I didn't do it, I would either get my pay docked, or I would have to do extra duties, or in that case, if I still said no, then I'd be sent to the lockup, and that's what would happen to me. So I did dye my hair back, and then I wasn't good enough. I got shouted at, and so I had to do it again. And so, it was just a matter of, those were the consequences. You pay, and it was a lot. Like, we didn't get a lot of pay, but if they docked your pay, they took a fair bit out. And the extra duties were pretty, not a lot of fun either.
And was there anything else about the Navy culture that you would like to tell the commissioners?
I think that the way say that because there were not a lot of women when I was in the Navy, then, as I said, there was a lot of men, and it was the way that we were treated as women, and just spoken to in such a derogatory way, and very sexually harassed, as I've said, all the time. And it was just, even like other female staff would just laugh, and it was just a given that people would make jokes and at your expense, sexist jokes at your expense. And yeah, it was that was such a huge memory for me of my time. It was, yeah.
And were you able to talk to anyone about this and about that happening to people and to yourself?
No, not at all. There wasn't anyone when I was at recruit school. When I was assaulted, there was no other female staff. It was men, and the only female staff she was a much higher up, an officer, and you never saw her. So there was no one to talk to. There were no counsellors. There was nothing like that. You just couldn't talk to anyone, really.
And would you say there was a culture of silence?
Oh yeah, definitely. Everybody knew the things that were going on, and we talked about, people joked about things. I can remember lots of stories about things that happened to other women, and people talked about it and joked about it, and it was just like common gossip, but no one kind of would say it there was like any like petty officers or anyone higher around. It was just that, we just all knew it was happening, and that was it.
And you mentioned before, when you were talking about when something snapped and going off the rails, what was the culture like when people would go out? Was there a culture around drinking or drug use?
Oh yeah, there was lots of drinking. I saw lots of drug abuse. I was initiated into drugs myself. It didn't, and this even happened in the quarters. This happened right where there were hierarchy living with us, and it was drinking was a big thing. It was constant, and there was always fights. There was lots of violence between sailors. It was just, and you were in a bubble. You lived in that defence bubble. You didn't really have any friends outside of that, because we were all working together, and most of us were sharing houses together, and so we all went out together, and that's how you lived.
And in terms of leaving the Navy, how long did you stay for, and what led to you leaving? And if you need me to ask you those questions separately, I will do that. So I just want to know how long you were there and reason for leaving.
I was in for 4 years, and I left as I got engaged, and I became pregnant, and it was a way for me to get out, and I left as soon as I possibly could.
And how would you describe your mental health after leaving the Navy?
It wasn't great. I suffered a lot of mental health issues from when I left right till now. It was an ongoing issue. I think I had postnatal depression after my first child. Even I had 3 children, and then it was up and down. after that. And it wasn't until that I was formally diagnosed that I could look back and see and realize what was happening to me, because at the time I didn't really know what I was going through. So when I was actually diagnosed with my condition, it made a lot of sense.
And again, without mentioning any dates, did you receive treatment for these mental health issues? And if you did, how long was it after leaving the Navy?
So the first lot of treatment that I actually received was probably only about say, oh, I'm just trying to calculate the years.
Was it
It was probably about,
Go ahead, witness.
probably about 12 years ago that I got my first treatment. And that was because I had another, I contemplated another suicide attempt, and I was hospitalised. And then I underwent 2 years of dialectical behaviour therapy for that.
And was that the first time then that you had received treatment after leaving the Navy?
Yes, yeah.
And did you receive any mental health diagnoses at the time?
Yes, I was diagnosed at that time. I was diagnosed with borderline personality disorder and also PTSD. But then that has changed. That diagnosis of the borderline personality disorder has now changed to bipolar disorder.
And in terms of suicidality, did you have any further suicide attempts?
Yes, I've had several since then.
And in terms of your diagnosis of bipolar, can you recall at that time what that meant for you and how you understood it?
It was a relief in a way, because it answered a lot of questions about what was happening with me and how I was, and what had happened to me after leaving the Navy. Like, things had changed, and that my behaviour, when I got the diagnosis and speaking to my psychiatrist, it was triggered by the assault in what happened to me in recruit school. And I could understand that when I actually snapped after I left there and went to HMAS Cuttable, that was the moment that the bipolar started to manifest.
And witness, you heard me say at the beginning that you were giving evidence about those experiences which you've now shared with the Royal Commission, and you were also going to give some evidence about your experiences with Department of Veteran Affairs. So have you had any dealings with DVA?
Yes, many dealings.
And how did you first get in touch with them or hear about them?
Well, my psychiatrist had mentioned he had dealt with DVA before, and we had discussed my service, and obviously with the diagnosis, and he had said, you could put in a claim. I originally, though, had when I was working, a lady that I worked with, she had her husband was in the Air Force, and she told me about the white card, because at that time I was having some difficulties, and so she said that you could apply for a white card, and that's how I managed to get the psychiatrist in the first place, because I applied for that and got it. So I went and saw the psychiatrist, and then he had told me about, that you could make a claim through DVA and told me that I could get an advocate. So I applied for an advocate through the RSL and then put in my first claim, liability claim.
And how was your experience with that first advocate?
It was really difficult because he was a man and I had, I found it really difficult. And he was quite an older man, and having to talk to someone about, sexual assault and trauma, it was really hard. And he was not that great either, and the process was quite difficult to understand, like even with an advocate. And so, and then the initial claim was botched from the very beginning with DVA. They completely botched the whole thing.
And we'll come back to that, witness, but in terms of that initial contact, how would you describe the support that you received from DVA?
Oh, there was no support.
And did you have any cause or reason to make any complaints about that at that time?
Yes, I had complained about the process of the claim, the length that it was taking.
And operator, please display WIT.0004.0001.0001. Witness, do you recognise this document? Can you see the document?
Yes, I can, yes.
And do you recognise the document?
Yes, I do.
And what is the document?
It's a complaint about a claim that I had made.
Witness, is it a complaint or is it a reply to your complaint?
Sorry, it's about, the reply for the complaint that I had made.
And in that, an operator, if you can please expand the paragraph that starts with the delay in claims. Thank you. And in that paragraph there, witness, DVA are telling you why there has been a delay, is that correct?
Yes.
And they're telling you there that they've received over 41,839 claims and that there was an 83% increase across all claim types. Can you recall how you felt when you received this reply?
I was angry. I was really angry because it felt to me like I was just being given statistics and a flippant reply that really didn't address my concerns. Like, it was like I was basically, it felt a lot like being treated again like a number, like I was just another person, that I didn't matter. It was, I can remember feeling really angry and just shocked, really.
Thank you, operator. You can remove that now. Thank you. And witness, you said before you'd made a claim. Have you made more than one claim?
Yes, I have made 2 claims altogether through DVA.
And what was your first claim for?
The first claim was the liability for the bipolar.
And was there an outcome to that claim?
Yes, they accepted liability, and I also applied for compensation under the DIRCA Act, and that was accepted as well. Compensation.
And you stated earlier that the claim was botched from the beginning. Can you tell the commissioners what you mean by that?
Oh, it sat there for quite a while, and I was trying to contact so you'll get allocated a delegate, and I kept trying to contact to find out what was happening, and they were never available. I could never get in contact with them. And then I ended up finding out that it actually went to the wrong place, that it shouldn't have gone to that particular person. It should have gone to another area. So it sat with this person for a couple of months until it finally went to the correct team, and so I was left in the dark. I didn't know what was going on, and I never got any kind of help or support from the advocate as well. So I didn't know. Basically, they filled the forms, put the forms in, and that was it. So I was on my own basically, and it just took forever. It was just unbelievable.
And you weren't working at this time, is that right?
No, I was on Centrelink payments, so I was in a really bad financial state, and I had lots of debts, and I could barely feed myself. I was in a really bad way. So it was a pretty horrific time at that time for me, mentally and financially.
And can you recall how much money you were living on per day at that time?
About $40 a day.
And were you able to pay your rent?
And it's no, because I ended up being my rent was in arrears, and I actually got an eviction notice, and I had to go to the tribunal to actually fight that, and to put in a payment plan so I could actually stay where I was.
And was this process impacting on your mental health in any way?
Oh yes, it was unbelievably. Because I couldn't talk to anyone. I couldn't find out what was going on. I couldn't. Sorry.
That's okay, witness. Please take your time, and if you would like to have a break, we can just have a moment now, witness. So please just take your time.
Yep. No, it's fine. It was really bad, and I just wasn't getting any support. Like, I expected DVA, because it was for veterans and for everything that I'd been through. I expected more, and I didn't get it.
Witness, when that claim was, well, firstly I'll ask this, was the claim settled, that first claim?
Yes.
And were you provided with a lump sum payment?
Yes, I was.
And can you recall any particular issues regarding that lump sum payment?
Yes. So with bipolar, one of the symptoms of bipolar is excessive spending. And I also had a gambling addiction because of that. Addiction is part of bipolar. And so when I was given $80,000, and I actually had asked for financial advice. I had asked several times for someone to provide me with financial help so that I could deal with that much money. It never happened. And so I ended up spending it and gambling it. And so I was left with nothing. And it took probably not very long for that to happen.
And did you have any dealings with the Ombudsman at that time regarding what was happening to you with DVA?
Yes, I had put in a complaint with them in regards to my claims.
And was there any outcome to that complaint?
No, because I actually, when I spoke to DVA and told them I put in a complaint with the Ombudsman, everything started to happen very quickly, and so I ended up withdrawing the complaint.
And would you agree then that it took that complaint for DBA to be able to respond to you in a sort of adequate time?
Yes, yeah. I feel like that's the only way they will listen. If you tell them that you're going to put in a complaint with the Ombudsman, then things will change.
And then you spoke a moment ago about how the claim was, how it was batched. Were you receiving any mental health support at the time, or in terms of either through DBA or any other services?
It was only just my psychiatrist, and then I ended up getting. I started seeing a psychologist as well, and so that were the only two supports that I had at that stage.
And did DBA at any time provide you with any resources or information about counselling or mental health support?
I was told about Open Arms, and I actually had initiated something with them, but nothing came of it. No one ever got back in contact with me at all. So that was I only did that once because it was basically it was useless. Nothing happened. I made the phone call and no one ever called me or anything like that. And then there was nothing else from DBA, so that was it.
And when you made that first claim, did the advocate assist you in completing the necessary forms and going through the process?
Yeah, they did the forms and they put the forms in, and that was really about it. That was kind of all that happened in regards to the advocate. Once I put the forms in and they'd done all that, I never really heard from them again.
And you then made a second claim, is that correct?
Yes, I
And
did.
in the second claim, did you have someone assist you with that claim, or did you do that on your own?
No, I did that on my own.
And how would you describe that process?
Just as bad as the first one. It was really quite stressful. I was actually in hospital at the time, and I got my diagnosis of PTSD, and so I did it myself, and I didn't understand much of it. And one of the forms that I had to fill out, the lifestyle questionnaire, there was a particular question that I had to answer that triggered me to the point of becoming so distressed and having a panic attack that I had to call Open Arms because I was not in a good place. And it was really, really awful. And I actually found out that I really didn't even have to answer that question, that I didn't even have to do the questionnaire. I could have stated something else, which meant that I didn't have to do it at all, but I didn't know that. So, yeah.
And at any point were you offered or allocated a case coordinator or a case manager to assist you?
That happened after that. So after that call to Open Arms, they started things in motion, and then I ended up getting a complex case coordinator.
And were you offered anything else through Open Arms at that time?
Yes, I ended up getting a peer support worker through them, who I now also have contact with on a fairly regular basis.
And how would you describe your experience with that peer support worker?
They've been pretty good, actually. They understand the situation and they have experienced similar, and so I can talk to them about my dealings with DBA, about things that have happened to me through my time in the Defence Force. So it's been quite beneficial.
And from the contact with the various people that you've had over the time, have you found that the peer support has been the most beneficial?
Oh, yes, by far. Much better than anything else.
And I know you may have partly answered this, but why do you say that? Why has it been so beneficial?
Because I think I can talk to them as a person that understands, who has had other experience and lived experience as well, and has had similar probably issues with dealing with DVA, because I've tried to talk previously to my rehab coordinators and even case coordinator about, and it's just like, it's like talking to a robot who is, because they're part of the system, they don't get it and they can't be objective and they can't empathize really much at all. It's just like, yeah, it's not the same. It's just not the same.
Thank you, witness. And you've just mentioned rehabilitation delegates, or is it rehabilitation consultants? Are they the same thing, rehabilitation consultants and rehabilitation delegates, or are they different?
No, they're different. So the rehab delegate is the DVA delegate, and they're the ones that look after all the rehabilitation, and they will deal with, like, if you want to do a course, they approve or whatever they do. I don't understand a lot of what they do, to tell you the truth. And then the rehab consultant is outsourced from another company. Like, they outsource it to employment companies or whatever, rehabilitation companies. So they're part of that. So they're not part of DVA in that respect.
And were you allocated a rehabilitation consultant?
Initially, yes. Yes, I have. And I'm up to my 5th rehab consultant now.
Over what period of time?
2 years.
And is there a reason why you've had 5 rehabilitation consultants over, did you say 2 years?
Yeah, because they don't know how to do what they're supposed to do, and they don't understand. A lot of them haven't understood DVA. They don't get how DVA works, and they just haven't provided me the support that I have needed. And so it's been really difficult. One of them was in Sydney, and so I didn't get face to face. One left, and the one I have now is local, but it's a male, which was quite difficult for me at first, and so that's been hard. But and a lot of them didn't give me the support and didn't contact me regularly. It was just didn't help at all. Like, I'm supposed to be rehabilitated in psychosocial activities to get out and meet people. I have really not done any of that through DVA. It has just not happened to date.
Can you describe what a little, you've answered this a little bit, but can you describe a little bit further how the rehabilitation process has been difficult for you?
It's how long it takes. So, for example, this year I got a new new rehab consultant in January, and I had put to them that I wanted to do a photography course. And from January until March, nothing happened. And I missed out on the course that I wanted to do because the communication between DVA and the rehab consultant was not happening. I was told that I needed to get a doctor's certificate to be able to do the photography course, which has never been mentioned to me before. I've never, ever had to do that before. So that was all new to me. And so it's just the time that it takes to do a course, even an art course. It takes so long. It's unbelievable the time you have to wait to even just to get that done. And I mean, I recently got my whole file from DVA and I went through it and I was absolutely shocked at the timelines and the amount of bureaucratic stuff. It's just about money. That's all I got from it. That was about money, that I wasn't a part of that process, really and truly. And so I'm still waiting to be able to do things and get out and reach those psychosocial goals. It's just not happened at all, because of the lack of knowledge and the lack of time, like the amount of time it takes.
And has there been any other situation that you can recall during the process of rehabilitation that has been difficult? Anything in terms of having to ask for something and then not being able to get it?
Yes. Before I was diagnosed with PTSD, my psychiatrist and psychologist had recommended that it would be a good idea for me to have a psychiatric assistance dog. Now, going by DVA, they will not provide a dog to someone unless you have a diagnosis of PTSD. And I couldn't understand why that was the case. So I actually asked about that and I received a reply with this big long email of why I couldn't have one. So then I was told that I could possibly ask for it to be put as part of my rehab plan. And so I emailed my delegate asking if I could get a psychiatric assistance dog, as I had tried to do it private, like through other organisations, and it just didn't work. It just wasn't going to happen. It just didn't work. And so I'd asked them if I could have that part of my plan. The email that I received absolutely gutted me, in that I was told that she could organise for me to go to a dog shelter and volunteer and to be around dogs that way. Or as I felt, it was like, you just go here and you can pat some dogs and look after some dogs, and that's it. And I was so angry as to someone could say that, when I replied that you don't even understand what an assistance dog does. You do not understand what bipolar is. You do not understand my condition. And you're a rehab delegate. You should know these things. I was absolutely disgusted in that reply. It really, to this day, is just upset me so much that someone could not even understand where I was coming from. It was really awful.
Witness, did anybody at any time during that process explain perhaps the reason why you were not perhaps eligible or able to get a psychiatric assistance dog?
Yeah, I got a reply back from the feedback people, complaints people. It was just a long email about the policies of DVA's policies, and it was basically was similar to the one that I'd gotten about the other feedback that I got when I put in a complaint about how long it was taking for my client. As much about a cut and paste reply as that was. It wasn't really, it didn't mean anything to me, really.
Did anybody get on the phone and offer to have a conversation with you about it?
No, and I actually have asked every time I have put in a complaint, I have asked for both in writing, and I've actually said I want to talk to someone on the phone, and no one ever has.
And have you managed to get a psychiatric assistance dog?
Yes, I have. Since I got my diagnosis, I have been successful in getting a dog, which I've had since October last year.
And when you say diagnosis, you mean the diagnosis of PTSD?
Yes, the PTSD diagnosis.
And how have you found having your assistance dog?
It's changed my life in a lot of ways. I'm able to leave the house and do things that I couldn't do. I feel safer when I go out. I can just be a more of a participant in life, I guess. I can even go to see my family. I couldn't travel to see my children before because I was too scared. I couldn't do that. Now I can with my dog.
Has it helped you become less isolated?
Yes, yeah, very much so.
And you talked about that you feel safer. Is that right?
Yes, very safe.
And how important are those two things to your mental health?
Oh, extremely important. I am very I mean, I still, even with my dog, it can still be difficult because I do get very scared in social situations, in large situations around males. I'm still very scared, but it has helped me deal with it a lot better.
And have you had any experience with the Commonwealth Defence Ombudsman?
Yes, last year I reported my abuse to the Defence Ombudsman in February last year, and I received back the report from them in January of this year, where they accepted my report and recommended reparation from the Defence Force for the abuse that I suffered in the Navy.
And and you've shared some of this already, Witness, and only to the extent that you want to. How have some of these experiences that you have shared with the commissioners today affected your life?
Unbelievably affected my life. My life would have been different if that had never happened to me. It affected my relationships with my children, my family, to the point where I can never get that back. I have lived in a way that was not my choice, that was taken away from me. It's affected every aspect of my life in, so many ways. I've suffered since then with other traumas. Because of that initial trauma, it's led to other things. And so it's been like an ongoing issue. And so, yeah, if that hadn't happened, I don't know, my life would just be so different.
Witness, is there anything you'd like to tell the commissioners in terms of what you think needs to change?
Oh, yeah. I think that DVA needs to not outsource their rehab. It needs to be internal. It needs to be people that understand the system. I think that DVA needs to realise that not every person, not every veteran went to war, that some of us were abused and assaulted, and a lot of it was men and women, and that because of that we have mental illnesses, and those mental illnesses impact our daily lives, and they need to understand that, and there needs to be more support and more education in how to deal with those kind of mental illnesses, and that they're ongoing, that these are not illnesses that are going to finish when they feel like they're going to finish, that these are going to impact us for the rest of our lives. And they need to understand that, or give more credence to this and to women, and to recognise women more, especially women with mental illnesses that have suffered abuse. I feel like whenever I look at DVA's website, whenever I see their news, it's all about men and it's all about war. But what happened to us is just not part of that, and it should be talked about more. I think it's really important that DVA, in relation to the VA and the DIRCA and all of that stuff, needs to get fixed, because I don't understand it. Nobody understands it. And how am I supposed to ever put in, if I need to put in another claim, how do I deal with that when I don't understand it and the people I'm talking to don't understand it? It doesn't make sense. None of any of those policies make sense to me. And so that needs to be taken into account in a big way to make it easier for people like me, for veterans, to be able to put in claims and to actually understand what they're doing.
Thank you, witness. And can I just clarify one point? When you say they don't understand it, when you were saying that you don't understand the various forms of legislation governing the various forms of compensation, and you said they don't understand it, did you mean the people who are supporting you, like the rehab consultants and the case coordinators? Is that what you meant by that, or somebody else?
Oh no, definitely. Either the case coordinators, they and the delegates, they don't even understand it. I've had to several times with the case coordinator. They've had to go and get information from other sources, which took ages because they didn't understand it. And so, if from my way of thinking, if a case coordinator, complex case coordinator, is going to help somebody, they need to know the system inside and out. They need to know everything about DVA and how it works, because if they don't know and I don't know, how is that going to help anyone? It's not going to help me if they don't know. And that happened to me probably all the time, every time, both of the claims, it happened both times, and even other questions that I've had since then in relation to other DVA matters, they didn't know. So yeah, it's an ongoing issue.
Thank you, witness. I have one final question. You've chosen to be anonymised today in telling the commissioners you're sharing your story and giving your evidence. Would you like to share with the commissioners the reason why you've chosen to be anonymised?
Yes, because I have ongoing dealings with DVA, I feel like that if they knew, then it could come back on me, because a lot of the time I have been, because of my mental illness, I have found that people don't take me seriously. That if I get annoyed or I disagree with something, and if I get upset, then it's oh well, you've got a mental illness, so what would you know? And that it's a label, and so I don't want to have that come back at me because I get worried about what DVA could do if they knew.
Thank you, witness. Commissioners, I have no further questions for the witness.
Thank you. Commissioner Brown?
Witness, thank you very much for your testimony this morning. I just had a couple of questions, if I might. You said early on in your testimony that you had made a complaint to the Commonwealth Ombudsman and you found that the response from DVA occurred quite quickly after that, and you said it's the only way that DVA will listen. Has there been more than one occasion where you've made a complaint to the Commonwealth Ombudsman?
Yes, I complained again. I've done it twice, and both times when I've said to DVA, I've sent through a complaint, things started happening.
Right, okay, thank you. My other question is in relation to the rehab consultant. You explained you've had 5 consultants over a period of 2 years, which I have to say must be quite disruptive for you. Are you given any choice in rehab consultant, or are you asked what kind of attributes you might be looking for? For example, you mentioned having a male was quite difficult, so are you able to express a preference for having a female consultant?
Well, I had, and they were aware of that. DVA are very aware of my situation. I don't know why this one is a male, considering that they knew that I prefer a female. So in that regard, yeah, no, I know they had to change companies as well. So I was with a previous company, and then they had to change companies because they couldn't find anyone in that company that could take me on, basically. So it was a completely different company.
Okay, so from what you're saying, there is some capacity to express a preference or a choice, but not an absolute or final kind of capacity to express that preference.
Yeah, no, it's not. It's basically in the delegate's hands.
Okay, thank you. And then just my final question. You mentioned earlier you were seeing a psychiatrist and a psychologist. Is that still the case? Yeah.
Yes, I see both on a regular basis.
Okay, and are you still seeing your peer worker?
Yes.
Okay, and do you still have your complex care coordinator?
No, I cut ties with them. I don't want to speak. I basically said, no, I don't want to deal with them.
But you have your assistance dog and then the rehab consultant. Yeah. Okay.
Yes.
All right. Thank you very much.
Thank you.
Thank you. Commissioner Douglas?
No, thank you for your evidence. I don't have any questions. Thank you.
The witness to be excused from...
Yes,
yeah.
Commissioners, I do have one more thing further. Can the witness please be released from from the summons?
Thank you again, witness, and you're released from your summons to appear today then.
Thank you very much.
If there's no other issues, we'll adjourn.
All rise. The Royal Commission will now adjourn until 1:45. The Royal Commission into Defence and Veteran Suicide is now in session. Please be seated.
Good afternoon, Mr. Singleton.
Good afternoon, Commissioners. With your leave, before I commence the evidence, might I address you briefly on the topic of this afternoon's panel discussion, which will involve Mr. Peter Sutherland and Professor Robin Craik, who are already in the witness box. Commissioners, you have already heard much about difficulties of transition from the ADF to civilian life and about the difficulties that veterans have in obtaining their rightful supports, rehabilitations, pensions and compensation. You might consider that the following statement reflects some, although not all, of the points that you have already heard prominently in your inquiries so far. There must be greater coordination between the ADF, military compensation, DVA and ComSuper to ensure ADF members are aware of their entitlements and that, as far as possible, an income stream is in place once a medical discharge occurs. This afternoon's panel discussion will commence with my tendering a paper by Mr. Sutherland. That paper gives an introduction to the complexities of the legislative regime. It also contains the statement that I quoted a moment ago and points out that that quotation was not made this year or last year, but in 1997, and yet still rings true. The paper speaks for itself, and I won't be asking the panel merely to repeat its content. Rather, we shall dip into a variety of issues, and I shall seek such opinions as the panellists may have on some of those issues, especially proposals for reform. From time to time, I may ask the panellists to address questions of law, even though ordinarily in a court, questions about law and evidence about law can't be given. And I may ask the panellists questions about finance and health and well-being, even though their expertise is legal rather than financial or health-related. The purpose is to maintain the coherence of the discussion and to put the legal issues into their factual context. One particular value of these panellists' opinions is this: there are many complex policy judgments to make, and minds can legitimately differ on how they might be made. And so it will be useful to hear from those who have studied these issues the most and for the longest. Because we will be touching on several issues, some discrete, it may be useful to have a brief and inadequate overview just to provide some context. That is, an overview of the legislative regime. The following overview that I'll give will necessarily ignore many details, such as exceptions to rules. It will use terminology that is not precisely legally correct, but it may give a hint at some of the issues so that the panellists' discussion can be better understood. As you know, Commissioners, there are three main acts, as well as several other acts, that provide the current regime for compensation and pensions and other benefits for those who have served in the ADF. The main three acts are the Veterans Entitlements Act of 1986, often called the VEA, the Safety, Rehabilitation and Compensation Defence-Related Claims Act 1988, often called the DIRCA, and the Military Compensation Act 2004, often called the MIRCA. They cover different types of service, different circumstances and different issues, and sometimes the same issues. And they apply their rules differently for different times or different time periods. One aid to understanding the complex regime is to recognise the great distinction that has been made for over a century between deaths, injuries and diseases arising from wartime service and deaths, injuries and diseases arising in other more peaceful circumstances. The former, to oversimplify, as I remind you, Commissioners, I am oversimplifying, the former was covered by a series of repatriation acts, and the latter were initially covered by the Defence Act and later by a series of Commonwealth Workers' Compensation Acts. That is, in the latter situation, ADF members were treated as approximating Commonwealth employees in respect of non-war, non-combat type injury and deaths and disease. The Repatriation Acts were replaced by the Veterans Entitlements Act 1986, and it, among other things, provides for pensions and compensation in respect of injury arising from warlike service prior to 1 July 2004. Meanwhile, the workers' compensation approach also developed over time. As mentioned, the Defence Act of 1903 originally covered non-warlike injuries. That changed in the late 1940s, when a 1948 Act caused the 1930 Act to apply to ADF personnel from 1949 onwards. And that continued until it was the 1930 Act was replaced by a 1971 Act, which replaced or continued until 1988, when the Safety, Rehabilitation and Compensation Act 1988, the SERCA, was enacted. It remained applicable, the SERCA remained applicable to military matters until 2017. In that year, the DIRCA was enacted. Although it was enacted in 2017, the DIRCA is cited as a 1988 Act because it retrospectively replaced the SERCA in respect of defence personnel. The need for a single system was recognised during the 1990s, if not earlier. Various reviews, some stemming from the Black Hawk disaster of 1996, led ultimately to the enactment of the MERCA, which covers injuries from 1 July 2004 onwards. Of course, many people are covered by 2 or even 3 of these main acts because they suffered injuries before and after 2004, and because injuries suffered in combat service and other injuries were suffered in non-combat circumstances. And further complication can arise when a pre-2004 injury is aggravated by events after 2004. It can be difficult for veterans, for their advocates, for the DVA even, to work out how the different provisions of the different acts apply to the veterans' different experiences and injuries over time. And after that, among other things, comes the difficulty of offsetting entitlements under one act against entitlements under another act. These remarks merely give a hint at the complexity. I will in due course commend Mr Sutherland's paper to you to provide more detail. Might I turn then to the formalities of getting the evidence underway? Could I ask the operator to bring up today, this afternoon's tender list so that I can indicate the 3 documents that I will tender. Commissioners, you will see all 3 documents. I will be qualifying the tender in this way. The major document, the one to which I will be referring in the oral examination of the panel, is the first one. Insofar as it refers to and purports to quote from the content of parliamentary proceedings, particularly the Constant Battle Report, we tender it not as proof of what was actually done in Parliament, but merely as this witness's understanding of what was done in Parliament and as a part of an historical narrative only. We will not be urging any inferences to be drawn contrary to the Parliamentary Privileges Act. With that qualification stated, and subject to a clarification which I'll elicit from Mr Sutherland in a few moments, I tender those 3 documents as public exhibits.
Thank you, Mr Singleton. They'll be accepted and allocated the next consecutive numbers.
Operator, might we bring up document DLR *00001.0021. Mr Sutherland, is this the cover page of the paper that you have prepared upon the retainer of the Royal Commission? And Operator, I'll just ask you to bring up page 003.
Sorry, Mr Sutherland, if you could just press the button in front of you when you're speaking. Yep.
Each of you will see.
Sorry, have
2
the witnesses, have they been sworn?
I thank you, Commissioner, they have not. Could I ask for that formality to be attended to before we go any further? And perhaps the Associate could make sure the microphones are switched on.
Mr. Sutherland, do you solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
Yes, I affirm that.
Emerita Professor Crikey, do you swear by Almighty God that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I so swear.
Professor Craik, could you tell the Commission your full name?
Your full name?
Robin Mary Craik.
And you are a Emerita Professor at the ANU?
I am.
Mr. Sutherland, could you tell the Commission your full name?
My name's Peter Henry Sutherland.
And you are a visiting fellow at the same university, among other things?
Our alma mater, the Australian University, in one sense, yes.
Yes, I was so keen to get into the evidence, I forgot the formalities, but could I now ask the operator to bring up page 0033 of the document previously on screen? Mr. Sutherland, there you tell me in conference that there's a slight confusion between the MCA, the Military Compensation Act 1994, and the Military Compensation and Rehabilitation Act of 2004. In the second paragraph after the dot point, you refer to the 1994 Military Compensation Scheme arising out of the Black Hawk inquiry. Do you seek to correct that
Yes.
by deleting that sentence?
Not the whole sentence, the words which was an outcome of the Black Hawk inquiry. That should be deleted because it's incorrect.
Yes. And I understand you found some typos in your paper.
Plenty of them.
And you would propose to provide us with a revised, slightly revised version of the paper for tendering in due course.
Yes.
Operator, perhaps I could now ask you to go to page 0021 of the same document. And Operator, all of the page references will be to this document during the afternoon. Oh, so that's the cover page. Could you go to 0078? Towards the bottom of this page, under the heading Legislative Reform, there's some 3-dot points. Mr. Sutherland, you say here that the VE...
Can you just point me to the page number, just so I can...
it's your page 58, if
Thank
that
you.
helps, at the bottom.
Yes.
You'll see that the first of 3-dot points at the bottom of that page is that the VEA is conceptually different to the Mercer-Durkar. Could you just give us an outline of the conceptual difference between the two approaches?
I think the fundamental difference that creates the problems is that the VEA is essentially a pension scheme, while the Mercer and Durkar are essentially lump sum payments or periodic payments for impairment and for incapacity for work. And the two don't mesh very well. You really have to make a choice whether to go with a pension which encompasses both impairment and incapacity, or a scheme that separately compensates both. And that's the real difference.
Professor Craik, if I could turn to you. Firstly, let me know if you disagree or wish to elaborate on what Mr. Sutherland's just said, but also could you address this question, whether you consider that either of those two models is more aligned with a well-being approach to benefits for veterans?
Certainly, the Circa and Durkar have been involved with rehabilitation and well-being much earlier than those who are covered by the VEA. The VEA has certainly made efforts in recent years to compensate and to introduce well-being and health and wellness concepts, particularly under veteran-centric reform. But, as I say, the Compensation Acts, Circa and Durka, are certainly, or certainly have those concepts embedded in them and have done for a very long time.
In effect, and correct me if you disagree, of course, but the extent to the extent that the VEA has these wellbeing rehabilitation elements, they're what's nowadays called retrofitted rather than embedded in the basic concept. Would that be a fair reflection?
It takes longer for cultures to change, and I think that culture has taken some time to change as well.
Mr. Sutherland, do you have a view on which of the two models, which are so conceptually different, more aligns with a wellbeing rehabilitative approach?
In general terms, either can achieve that. It's a question of the culture of the administering department and the stakeholders. And there has been a convergence, like the VEA has. There's been extra parts put into the Act to do with rehabilitation and family provision and a whole lot of stuff like that. But that's sort of after 60 years or something, really, that they're bringing in these concepts into the VEA. But there's no intrinsic reason why any scheme can't have a wellbeing approach.
Operator, could I just ask you to go now to page 0022? Mr. Sutherland, there appears to be little controversy about the existence of complexity in the regime for military pensions and compensation and so forth. Two of the reasons you've identified for this complexity are firstly the long history of deployments overseas usually and consequential reform, which seem to have added layer after layer of change. And secondly, a standing policy or a long-term policy of generosity for veterans, which has weighed against removing any existing entitlements whenever reforms are in fact made, so that grandfathering occurs. Can I ask you this? Are you able to say whether grandfathering has been a feature of the legislative history all the way back 100 years, or did it come in at a later time?
I can't say that in relation to the VEA before the Repatriation Acts before '86, because I only see it as a bit of history. I wasn't working in the field. In this area, I think grandfathered entitlements. The word grandfather is, I suppose, very gendered now, but that's just been the way it works. It has been as long as I've been in the field.
Yes, I suppose, just for clarity, grandfathering is a term, however antiquated it might be, to
makes
indicate
sense, doesn't it?
certain existing rights or entitlements will be kept, but the door is closed, nobody else can get them.
There is another concept which goes with grandfathering, that is also freezing, which I'm not sure that I mentioned in the paper, but it's quite often used in the social security environment, where not only do you grandfather the entitlement, but you freeze the level of entitlement so it doesn't increase, and over a period of decades, or sometimes years or decades, the two converge because inflation is not applied to the benefit. So that I don't know that that's used that much in the vets area, military comp area, but it certainly works in the social security area as a way of reducing the longevity of these grandfathered arrangements. You know, it takes about sometimes 5 to 15 years for them to disappear, but it happens because of inflation.
All right, Professor Craik, if I could turn back to you. You, I understand, have prepared some notes or a draft paper of sorts that you might be prepared to share with us.
Council, on reflection, it may be better if I deal with the issues as they come up, and if there are any which haven't been covered, at the end of the session, I'll deal with them, and I can always produce a brief paper.
All right, well, I'm quite happy to do it that way. Mr. Sutherland, if I could just come back to you for a moment. In your opinion, does the current 3 Act regime cope well with the problem of determining what act applies to what injury, what aggravation, of working out whether perhaps an injury that emerged over a long period is attributable to peacetime service, wartime service, or something else?
It's relatively simple to tell whether something is related to wartime service because that's defined by military operations. The Department of Defence essentially defines what is warlike service, but to try and work out what particular act applies to a particular injury or person, not even lawyers can tell you. Half the time you're guessing, you're making your best informed opinion. It's just not an area that's of any simplicity at all, whether you're a lawyer or a stakeholder or an advocate or a client or sometimes perhaps the DVA. You know, it's just very difficult.
Insofar as it might be quite easy to work out whether a particular injury is war-related, is there a distinction between a blunt physical injury that occurs at a particular time, on the one hand, and perhaps a mental health issue that might emerge years after its true cause?
Oh, the aggravations of a particular injury and what happens with the disease is impossible to be certain about. You know, I don't think doctors can do it. You know, in the end, it's a matter of medical opinion sometimes. And, you know, what is clear is that you're referencing a particular form of service and you can generally say, well, that's going to be warlike or non-warlike or peacetime. But when you start getting the downstream effects of injuries, and particularly mental health injuries, it becomes very complex.
So, Professor Craik, if I could ask you this, where there is a distinction of rules that turns on when an injury occurred, there can be those pragmatic or practical difficulties in working out how to apply the law to them. But could I ask you a question at the level of principle or philosophy? Are you aware of any arguments that have been advanced in favour of providing a better compensation regime for injuries occurring in combat compared with injuries that might have occurred in the barracks or the staff office in Canberra or somewhere else?
Can you just repeat that last part of that question, Council?
Yes, so I'll almost reverse it to get the clarity. Essentially the same injury might occur sometimes in a combat situation or in a domestic employment situation in a Defence Department building. So one is on duty, one might be lifting the filing cabinet as opposed to lifting some munitions in the field, but it's the same injury. It is sometimes suggested that one of those injuries should be compensated better than the other. Are you aware of any of the philosophical or principal arguments in favour of a distinction?
The long-standing argument in favour has been that military service requires a diminution of some of the freedoms that civilians enjoy, and a price for that loss has been some beneficial approach to treatment of defence injuries. And I think that's probably the strongest argument in favour of defence injuries being treated differently, even if the same injury in a civilian context might have had the same outcome. There are some special types of injuries as well, which probably only or principally develop or have a particular resonance in the defence context. I'm thinking of things like mesothelioma, and a little while ago you asked Peter the question about mental health injuries. Mental health injuries too have a very strong, long latency period. And in defence service, there may well be more triggers for mental health issues to arise, just like service in the Navy, where you lagged pipes, led to many claims for mesothelioma. So these are some reasons, both at a practical level and a philosophical level, for the distinction to be made.
If I may say so, going right back to the beginning of your answer, you've presented an argument based on deprivation of ordinary freedoms because you're in a disciplined force. That's an argument for saying that the civilian compensation system should be less generous than the military one. But is there an argument that says a military person injured doing work in Australia, not in combat, should get less, that military person should get less than another military person who happened to be getting the same injury in combat? Is that distinction a valid one?
You mean the same injury in a wartime or non-warlike service?
Yes, same injury, both to military
Again,
personnel.
the likelihood of some of those types of injuries is increased. I was thinking about this in relation to, for example, high blood pressure, which can be caused by ingestion or high ingestion of salt. Service in the tropics often led to the demand by commanders for service personnel to have salt tablets. My father was in that context in Papua New Guinea, for example. Now, that often led, those salt tablets, to a taste for a lot of salt post-service, which again might have led to high blood pressure and maybe some heart conditions as well. So there are some types of injuries which have a peculiarly apt association with service, which probably doesn't arise or don't arise in the civilian context.
Mr. Sutherland, do you either disagree that there can be special, I'll call them special injuries, because they are so distinctly related to combat or similar service? That's one question. Do you agree with that proposition?
Yes, I think there is injuries that are made that are in some ways impacted by actual overseas military service on active service. I think the point I'd make, though, is that I'm probably a strong proponent of the fact that there needs to be recognition in our compensation system of the unique nature of military service in operational areas. Now, it's a very contested area, and that's why you're asking the question. I was on the military compensation review in 2010-11, and there were 6 members of the committee, and 3 thought there was a unique nature of military service that should have compensation entitlement impacts, and 3 thought the opposite. I think the impacts of operational service overseas may probably have some relationship with the level of entitlement, possibly, I think so, but probably more importantly, I think it does have a lot of impact into when you determine a person should have entitlement. In other words, I think there needs to be a recognition of the overseas service and a recognition of the difficulty those people faced in war or in operational environments. And I think, therefore, I suppose it does impact on things like standards of proof, evidence required, possibly certain types of entitlements that should be given. Whether you should have a direct additional amount of money, it's more contested, but in the military compensation review in 2010, I accepted there should be a differential in the area of permanent impairment. And I don't resile from that. But for me, the thing about operational service overseas, which contrasts it with peacetime service, is that the people are under discipline and they have to take risks which they have no control over. I think that's what happens, that you are forced into an environment where to not obey orders is to create a military offence and also to let down your comrades. And you have to accept sometimes terrible risks. And that is simply different from a peacetime environment. There are dangerous situations in peacetime environments. The most dangerous probably we can ever recall is the Black Hawk helicopter crash, which killed, I think, over 20 service people. It was a training exercise. So there is danger in peacetime service, but I think there is a unique quality of the risk that's undertaken overseas in active service. And I just think that it comes down to some personal opinions, I think. It is a contested area. There are also dangerous peacetime occupations that are not military. I would say that underground coal mining and forestry are probably more dangerous industries than the military forces in peacetime, if you look at compensation stats and so on. But there are, some of the training, particularly the training pre-deployment can be extremely, the live fire training can be dangerous, and we have had deaths in pre-deployment training. So it's not to deny there's no risk or that's a lower risk, but it is covered by work health and safety procedures in peacetime service. But overseas, those things just sometimes can't be accepted. It's just too dangerous. The people have got to do their duty.
One argument that has been advanced, contrary to your position, I think, and so I'd get you both to respond to it, is that the current arrangement provides an incentive for people, for members of the ADF to make sure they get a foreign deployment because their prospects of compensation and pensions and so forth are better if they've had that deployed service.
Can I answer that?
Yes.
I just don't think it's very true. My experience, again in the military compensation review, as I went to quite a number of barracks, and I must say the people there, except the ones who'd been deployed a great deal, like the SAS people in Perth in the barracks there, they didn't think about compensation. In fact, their focus on overseas deployments were twofold, I think. One was because that's what they trained for, but the other was, of course, there is massively increased remuneration overseas, tax-free allowances, a whole lot of financial incentives to actually do it. So I don't think the compensation is the driver for that determination to go overseas. I think it's culture, it's remuneration, and it's spirit. It's the collective. It's what you've trained for, and so that's where I think the intrinsic thing is. People tend not to think about compensation until their first injury.
Professor Craik, last word to you on that topic.
I would agree with Peter that the overseas or the attraction of overseas service is the extra money that's involved and the extra benefits and entitlements which are received as a consequence of overseas service. So I think that does make a distinction.
Thanks. I'll move on to a smaller point now. Operator, could I ask you to go to page 0027 and to scroll down to the bottom of that page. Mr. Sutherland, this is page 7 of your report or article. And here, to paraphrase, you suggest that the compensation regime established after the World Wars in Korea was not well suited for Vietnam veterans. And then you say that the community's opposition to the Vietnam War and conscription contributed to systemic failure, and that these failures had a marked effect on the complexity of the military compensation scheme. Could you explain how those failures led to that complexity?
I'll start with the failures. Like I was not conscripted, I was balloted out, but I was in the CMF in the Queensland University Regiment for 3 years. I remember the Vietnam period, and I became violently anti-conscription eventually. When those people came back, not in the early years, not around 1965, 1966, but by late in the Vietnam commitment, when those servicemen came back, half of them had been conscripted, were national servicemen, they basically disappeared into the community very fast, and if they put their heads up, they were reviled. And it was not a personal revival, they weren't being personally attacked, but just that there was such a community opposition to the commitment to Vietnam and the conscription that they were simply not accepted back into the community very well. That's my personal experience of it. And I think, and again, I'm going back to history, but I think I've identified in my studies that those people essentially didn't enter the compensation system until sometimes later in the 1980s, really. It took almost 10 years, and that was after some quite massive battles, particularly by the Vietnam Veterans Federation and the Vietnam Veterans Association of Australia, to actually get recognition of Agent Orange injuries and general injuries coming out of Vietnam. As I understand it, for example, the Vietnam veterans essentially weren't welcome in some of the ex-service organisations. I'm not sure about that, but there was just a distaste for the Vietnam War, and it carried over to the unfortunate individuals who were conscripted or voluntarily went there. And I think their compensation needs were under-recognised for at least 10 or 15 years, and it led to a lot of self-medication with alcohol and drugs and a lot of family distress during that period. Like the Vietnam War and the veterans are now completely accepted inside the system, but it took a long time, is my personal memory of it.
So could I summarise the point this way? The added complexity arising from that social context was not a legislated complexity, but it was the administration of the law and the willingness of veterans to actually seek their entitlements. Is that the nature
Probably,
of the
though there was
complexity?
also dual entitlement came in, which certainly didn't help complexity.
So is that a reference to the change in late 1972 that enabled veterans to choose whether they, in some circumstances, whether they claimed under the Workers' Compensation stream or the Repatriation Act stream?
And that added considerable complexity to the whole system.
Yes.
But I suppose I'm referring more to a social driver of that problem rather than it being specifically legislative. There were legislative problems, though, that the fight to get recognition of Agent Orange injuries was very deep, very deep.
Yes. With that, perhaps just for the interest of time, I'm going to ask the operator to go to page 0029, page 9 of your report, Mr. Sutherland. And I just want to get a clarification of the structure of the VEA regime. I realise, Professor Craik, you're the...
She's the expert.
You're the expert.
Necessarily.
So feel free to argue amongst yourselves as to who answers these questions. You'll see on that page we have the beginning of a list of key features of that scheme, beginning with initial liability, and the next one's disability pension, and then medical treatment. And those terms are underlined just for ease of reference at least. My question is this: is the entitlement to a disability pension an issue that only arises after initial liability has been determined?
Yes.
And is it the same with medical treatment?
Under the VA in those days, yes. We have non-liability treatment now, but that was not a concept that I think was really understood or accepted or used in that at that time, I don't think.
And then over the page, the top of page 0030, allowances are then paid to veterans in receipt of a disability pension. Is that available only if there's been a determination that there's to be a disability pension?
Oh, yes.
So,
well, sorry, it might...
Can it come up?
Pension, some of the allowances might be payable, like the travel allowance maybe arise from some other entitlement under the VEA, but essentially they're tied with disability pension because that's the main entitlement under the VEA. There's not really anything else. You start with a disability pension at some level, and then medical treatment allowances, everything else flows from that.
And there can be is this right, a series of separate decisions that have to be made.
Oh, there always is.
In sequence.
And they keep going for years and years. It's called an application for increase, an AFI, and people on the VEA basically just keep putting in AFIs. Every time the disease changes, worsens, something new happens, there'll be an AFI to seek to get the liability accepted for that new condition. And it's the nature of the scheme.
Well, if I could ask the operator to scroll to the bottom, there's near the bottom, there's a heading veteran payment. And there you write that this payment is payable to a person making a claim for mental injury or disease under the MERCA or the DIRCA, or to their partner. Is it available? First, it's an interim payment to hold the fort whilst any delay at the DVA occurs, and once the claim is actually determined, that's the end of the veteran payment. Is that right?
I think so. That's my understanding.
Council, it very much is so, because I think it's set at 45 weeks as a maximum. So it's a temporary payment, the veteran payment.
So if the delay in processing your claim is a long delay of more than 45 weeks, then you don't continue to get the payment.
I don't know that.
You might have a little break, yes.
I don't know.
And as best Professor Craik knows, that might be the situation, but and we will always...
I object to that. That's not what the answer was.
I'll just ask it more directly. I may have misheard. Professor Craik, does it come to an end, at least for a while, after 45 weeks?
I think it can be reactivated, but certainly it's finite initially, and then, as I say, it may be able to be reactivated, but you've got to go through the application process again, of course.
And the main question I had was this: is it available for physical injury or disease? Pending a claim for such.
I think it's only available for mental injury.
If that's the case, and obviously we can ultimately check the Act, but if that's the case, can you see a reason in principle or philosophy for saying that such a holding interim payment is available for one kind of injury but not another?
Again, I think it's probably a product of a time and place, Council. We have become much more conscious of mental injuries. And going back to your questions to Peter about the Vietnam War, I was thinking about the many cases I reported which have focused on ex-servicemen who were in Vietnam. And for many of them, as Peter was indicating, alcoholism but mental health injuries were very high on that list. And many of them rejected Anzac Day, turned away from their families. The social implications were significant following that particular conflict. And that, coupled with the current focus on mental injury, perhaps justifies the fact that there is this special payment for the veteran payment for mental health injury and disease. And I think that's a feature of 21st century Australia, that we are becoming a lot more conscious generally in our community about mental illness. It's come out of its closet to some extent, and as a consequence, we are better attuned to the need to act to rectify situations and to improve the position for those who are sufferers.
To turn it in reverse, is there a good reason why physical injuries should not attract the same veteran payment? That you can think of.
Possibly not, but as I say, these things are often socially reactive, and mental injuries and diseases at the moment are benefiting from that facet of society's behaviour and the politicians' behaviour.
Yes, Mr. Sutherland, I think you've given us 20 or more pages of description of how just things accumulate historically, but do you see a reason in principle why a veteran payment shouldn't be available for physical injury claims?
Not as such, but I think that the veteran payment is essentially an interim solution to a bigger problem. I think the problem is that people can discharge from military service without their injuries having been assessed and compensation already, or at least the transition process needs to make sure that people don't leave before these things are actually at least identified. If the person chooses not to do anything about an identified condition, then really that's difficult, and it does happen. But really the answer is not to sort of keep expanding the interim payment of this nature, but rather to improve transition inside the ADF and the relationship with the DVA and the Superannuation Commission, so that people can't discharge until they've had the opportunity to be assessed, and therefore that they will, if they're entitled to a financial support payment, incapacity payment or medical treatment, then that's actually put in place the day before the day they discharge. And so rather than continuing to band-aid interim payments, which are good, they're necessary at the time, I would look more fundamentally back at transition and improve that.
Assume that more fundamental solution was enacted and implemented. Perhaps I could ask you to turn your mind to a different scenario. Assume that a person was discharged in an appropriate way, proper transition for a couple of years, and it all went well, but a latent mental health issue emerged. It might be triggered by an issue 5 years later, but it is...
You're right, an interim payment is appropriate there.
And at least potentially the same could happen with a physical injury. It might be mesothelioma, might emerge, and a claim might be made in spite of a good transition. So for such a situation, you wouldn't oppose interim payments?
No, I'm not particularly familiar with the veterans payment and why and how it happened, but I can't see conceptually why it should be different. Why it should only be mental health. But
Council, can I just add something to
Yes.
my comment about the social pressures? For a very long time, it was a feature, I think, of the culture within Defence that you didn't confess to mental illness. So it wasn't even known or identified, at least possibly till assessment prior to leaving the force, or, as you suggested, sometime later. So that too contributed, I think, to the attitude of, or the development and the late development of focus on that area.
Operator, I might just get you to go further up the same page. This is page 0030 of the document. It's also page 10 of the document. Under the heading Service Pension, there's a discussion of parts 3 through to 3E of the VEA, and there's a brief discussion of the age service pension and the invalidity service pension. Firstly, Mr. Sutherland, could I ask you this about the description of the invalidity service pension? It appears to suggest that the invalidity service pension is different from the ordinary disability pension under the Social Security Act in this regard. The military one requires a permanent incapacity for work. Is that a distinction?
there is definitely a difference.
Now, is there a legitimate rationale for saying that if you are a military person, your incapacity must be a permanent one, but a civilian doesn't have to meet that high standard?
I don't think that's the correct characterisation. The Social Security Act, the disability pension, used to have a test of permanent incapacity for work, a well-known test, lots of federal court jurisprudence on it. The government chose to remove that test and introduce a new test based on impairment tables into the Social Security Act. And I must say it's a test that is under great community stress at the moment, and in recently a parliamentary inquiry recommended massive changes to the Social Security Disability Support Pension because that particular approach to disability support pension is not working. The permanent incapacity for work part of the service pension, I'm not sure that many people actually apply for it or go on it. I think it's a fairly small subset because what is important is, of course, the disability pension under the VEA itself, if you're on that area, or, of course, entitlements under the DIRCA, or your superannuation invalidity pension. I think the service pension, invalidity service pension is, I think it might be relatively underused, not very used very much. I think a DVA person would have to look at the numbers, I don't.
Yes.
But it really is a very small backwater, I think.
Yes, assuming because it...
But the test that they use, I think, is the appropriate one. I think what happened in Social Security was the problem.
So the Commonwealth Superannuation Corporation, which deals with superannuation, also deals with disability pensions.
Yes.
And so one might well be catered for under that scheme.
Well, we've got three, haven't we? We've got the disability pension under Part 2 and Part 4 of the VEA, then we've got the disability pension and invalidity pension under the super schemes, then you've got the invalidity service pension. Like, this is part of the mishmash.
Nevertheless, there might be, as you say, a few people who are on this pension. Could you comment on whether it might be better to change the requirement from a permanent incapacity to an ongoing incapacity for the purpose of trying to encourage rehabilitation rather than encouraging perpetual disability?
I don't think it's necessary because permanent incapacity for work means likely to continue for 2 years or more. I think that's McDonald's case, if you want to look it up. But it's well known that permanent incapacity for work in legal terms now, because of this decision of the federal court, means likely to continue for more than 2 years, which I think is probably right. So permanent, you could leave it out, but hopefully that wouldn't mean to say that you move on to invalidity service pension at the drop of a hat. I think it's something that probably does need a level of consolidation of the injury before you go down that road. You want people to go into rehabilitation, not to set themselves up for life on an income support payment that doesn't encourage them back into the workforce.
Is that a principle you'd agree with, Professor?
It is. I mean, there's a real tension between rehabilitation and taking a pension or benefit which will feather bed you for life. So that is inherent in some of the system and needs to be addressed.
All right. Perhaps I'll ask the operator to go to page 0032. Mr. Sutherland, this is your page 10. At the bottom of the page, there's a paragraph with a dot point right at the bottom, which can be enlarged on the screen a little bit. Here, Mr. Sutherland, you note that under the circa, by reason of its general, that is not military-specific application.
I'm sorry, I'll need to find the page.
Page 12 of your document.
Second dot point, was it all?
The last dot point right at the bottom of the page.
Right, okay, got it.
So you're talking about the circa, not including any significant measures specific for the ADF.
Oh, yes, of course, the practical side of the business, yes.
Yes. And then you make this point: compensation for incapacity and medical treatment become relevant only when a member was discharged from the ADF. Now, that's the circa. It's been superseded by the DIRCA, which is a mirror image arrangement. But is it still the case that that kind of compensation can only arise after discharge, or is it?
It's not that it can only, but it does only, because people receive their military salary and receive medical treatment while they're in the forces.
I see.
So there's simply no reason to apply for incapacity compensation or medical treatment. That's the reason. It's a practical reason, not a legal one.
So that's a practical reason from the point of view of the soldier or sailor or aviator. But perhaps try and look at it from the DVA's point of view. Would they perhaps benefit if there was early reporting of these matters?
Oh, I think that's what everybody's trying to do. You really, like as the Productivity Commission, I think, said, you really need to start considering compensation issues or military compensation the day the person joins the ADF. You know, you need to make sure they're medically fit when they start. You need to have a baseline for some of the issues, health issues, and then while they're in service, you need to try to get good recording of workplace health and safety issues, dangerous incidents. You try to get that recording. And also, of course, the one thing about the ADF is that you generally have very good medical records. The person hasn't claimed a medical compensation under the various military compensation legislation, but they've got their service medical records. So you've got a really good view of what happened to the person and what their health issues were while they're in service. You just don't need the military compensation system for medical treatment until you discharge. I think that's the point. And incapacity is the same. You're already being paid your salary. Incapacity compensation cannot help. It can't give you more money. And also, of course, then as Robin, I think, said, you're admitting that you've got a problem, you know, and that's something that in military is very difficult to do because it affects your promotion, it affects your position in the unit, all those things. So there's a great pressure to not disclose injuries and not disclose health issues, but the health issues are being recorded.
Professor Craig, would you wish to add to or detract from that analysis?
No, I would agree with what Peter has just said.
All right. Well, I'll ask the operator. Sorry, did you want to? Sorry, I thought I might have cut you off. Anything more?
No.
No. Operator, could I ask you to go to page 0071? Mr. Sutherland, this is page 51 of your paper. Just to give some context here, I'm going to ask some more questions at the broader level rather than the historical detail. But this page 51 is a part of section or part 9 of your paper, the last part with a military compensation, and you address a number of broader forward-looking policy issues and conclude with some reflections of your own. I've already asked some questions that go to your first section, which is war and peace and the operational environment. The second is unravelling legislative complexity, and I and there's a number of elements. I just want to go to the one that begins at page 51. There's a heading, One New Act.
Yes.
And you'll see there, and Professor Craik, I'll come to you first because Mr. Sutherland's already written down his view, and then I'll come back to him to rebut you if necessary. You'll see here that the preliminary interim report by the interim national commissioner is mentioned. There's a recommendation 4.1 is quoted, and Mr. Sutherland opines in the next paragraph just before the dot point that it's not practicable for reasons that he gives. On the other hand, and I'll ask the operator to go forward to page 0078 for a contrast. So just bear in mind that Mr. Sutherland thinks that the interim commissioner's proposal may not be practicable for reasons that he gives. But at the bottom of this page, under the heading Legislative Reform, Mr. Sutherland says, I consider that the two-scheme approach proposed by the Productivity Commission offers a reasonable chance of achieving substantial legislative reform, although undoubtedly the process will be highly contested and painful for all involved. Now, obviously Mr. Sutherland knows how to sell a matter politically, but Professor Craik, could I ask you whether you have an opinion on whether these two models for the future whether you would prefer one over the other, or maybe you're aware of a third that might be better than both?
Can I just say this, that politically at the moment, I think there is no option but to have at least two schemes. I think there could be amalgamation between Circa and Durka, and should be. But given the longevity of some of the entitlements, it'll probably be beyond your and my lifetime before some of those aspects of the Veterans Entitlements Act have been fully worked through. So I think that we are bound to have two schemes. And I think two schemes is workable politically and practically for some time. So yes, that would be my approach to that big question of whether we have one or two acts.
Can I ask you to comment on this proposition? It's a set of propositions that go together, that minds could legitimately differ on what the best way forward is, that we've been debating these issues for years and years, that the chances of getting a dramatically better model than already thought of are small, and that the best way forward is just to pick the best one on offer and go with it, because any further delay is too detrimental to warrant waiting for an illusory perfect model. Do you think that's a right or wrong analysis, or something, a mix of the both?
I think it's the ideal to pick one and for the future, but I do think the grandfathering is going to go on for some time. And I think there are aspects of the current legislative regime which can in fact simplify the administration of the schemes. And I think it's within the administrative area that we need to speed up the process. As my report into the Jessie Bird's suicide indicated, it is in the administrative area that much of the problems arise. The delays that occur in notification, the IT problems between Defence and DBA, and also some of the review system and even the SOP system can be improved in a way which will diminish some of the pressures on administrators by simplifying the processes. And I think it's these which we need to focus on, with an ideal model available in the future, but for the immediate present, I think some of these issues can be dealt with and dealt with now. There are, as I say, or will say, there are some financial imposts even on the sort of changes that I would suggest to SOPs and other matters. But I think overall, they can be achieved if government is willing to pay the extra cost. And I think that extra cost can probably be balanced against some of the increased health and welfare and productivity outcomes if well-being and health developments are actually implemented in a very sustained way. So the two can balance themselves out.
Mr. Sutherland, could I get your views on the relative importance of administrative process improvement and particularly IT being used to help that?
I think the administrative improvements are the critical thing and the urgent thing. We do need legislative reform. It's very difficult because every time you try legislative reform, another set of grandfathered entitlements emerges, and it's very hard to deal with that. There are very sensible legislative changes which can be made to improve the schemes, but ultimately it's really about the administration. And then secondly, I think that the MERCA is in fact the one big new act. I think you could create a new act, but I think MERCA gives us the basic grounding for getting it right. We said that in 2011 in the MERCA review. There's a lot wrong with the MERCA, but I think that is the one new act. And I agree with the Productivity Commission that we need to park the VEA in Scheme 1 and let it die out by about 2080 or 2090. You could make it quicker if you wanted. There's things you can do to bring it back. We can probably have the VEA gone by 2050 by certain actions, but in the end, I think we've got a residual scheme. Let it residual out as people essentially come to end of life, and we have to focus on the new act, which is the MERCA Act, 2004. The complexities legislatively relate to injuries before 2004. Since then, it's the one act. There are problems with that act. We need to fix those, but administration is very much where the game is, both in ADF and DVA.
Council, can I just
Yes,
say
please.
that the MERCA is very much the act which is administered by the department now. If you go into the department and talk to the officers, it's the MERCA that they're dealing with, and the VA has already started to slide into history, but as Peter has graphically indicated, it's going to take some time before that end point is reached.
I could ask the operator to go to page 0072. There's a discussion, this is page 52 of your paper, Mr. Sutherland. There's a discussion of, under the heading Improving Scheme 2, the MERCA, Incapacity Provisions. Just so people can grasp this in context, I think, correct me if I'm wrong, Mr. Sutherland, but Scheme 2 refers to the second productivity scheme. When Productivity Commission recommended the future, they said, let's have a two-scheme model. Scheme 1 would be the VEA, Scheme 2 would be the MERCA.
Yes.
And you're now discussing one aspect of improving the MERCA, namely provisions relating to incapacity. Is that
Yes.
the way we should understand that? Now, one of the difficulties that can arise from reform is that every time a reform is made, there's a risk that either you have to grandfather or keep lots of old provisions, or someone loses out. And if you do the former, you just add to the complexity. I realise I've oversimplified it and you've explained it in the paper. But here in this discussion, you make the proposal, if I understand it, that where some entitlements are being removed, they might be removed but compensated through superannuation. So one might get a simplification, but there's an offsetting superannuation-based scheme. Now, firstly, if I oversimplified or just got it wrong, I'm looking at the last few lines of that discussion.
I'm not referring to the military superannuation scheme there, but rather to the fact that when an individual in the military is on CIRCA or DIRCA and receives incapacity payment, they are not getting the superannuation guarantee payment, the 10%. So that if, for example, you have a young person, very young person injured, seriously injured and they go on to incapacity payments for the rest of their life till age 67. They get to age 67, retirement age, the incapacity stops, but if they've been on incapacity their whole life, they will have no superannuation that they themselves have accumulated, the 10% that everybody else in Australia gets because they're an employee. So I'm saying that, as I said, the additional payment, the $100 add-on, I think is just too much, too far. But one of the ways possibly that could be dealt with is to actually look at the fact that it could be traded, and these things are all about trades and compromises, and it could be traded for actually introducing the superannuation guarantee to military compensation incapacity payments. That's what I'm saying. Yes. It's not an issue about military compensation. It has its own terrible complexities, including legacy schemes. I'm just saying that what I'm saying primarily is that I think incapacity is wrongly structured and too generous. And I say too generous because it fights against the absolute imperative for people to go back to work if they can, because it's lifetime income support is not a good human option. There may be no choice for someone who's irredeemably injured, but it's not a good choice for people to think, well, now I've got my pension for life and I'm going to sit on it. We need to get people back into work to the extent they can work. And if they can't actually go back into the paid workforce, then we need to make sure that they have a really good psychosocial rehabilitation opportunities. And I think the incapacity payments at the current level tend to fight against that really desirable outcome of incapacity payments. That's what I'm saying.
Yes, no, I think your paper points out the incapacity payments have risen from, can't find it, but...
No, that's the add-on.
The add-on.
Yeah, just by inflation, that's all it is.
It's now at $171 dollars a week, and you conclude with this, and it's the last sentence, perhaps the removal of this additional payment could be compensated by introducing superannuation guarantee payments on top of incapacity payments and so on. Has this proposal been considered by government at all, do you know?
In relation to ADF, I don't think so. It's been raised in some other contexts I'm aware of, though. I think it's being raised, for example, in relation to the CIRCA scheme, the Commonwealth superannuation scheme, which at present doesn't have a superannuation guarantee in it. But conceptually, I think the superannuation guarantee should apply to these types of payments so that people have a personal accumulation of superannuation when they retire at age 67. I think it's a problem that the compensation system doesn't actually provide that. But it's only one possible. I'm suggesting as a trade-off. It's good policy in itself, I think. But it may be, I think that the additional payment is bad policy. I think it was bad policy at the beginning and still is bad policy.
I just get the operator to scroll down just a little bit on this page just to see the next heading, which is Improving Scheme 2, the MERCA. I've explained that. And now you turn to Review of Decisions. And you, as others have, describe how there are different review provisions depending on what Act one is working under. If I could ask the operator to go to the next page, 0073, and in the top half of the page, among many other points, Mr Sutherland, you say this in the third paragraph, or the second whole paragraph. Over the life of the MERCA, there has been surprisingly few concluded decisions by the AAT on that Act. And you give some statistics and then you contrast it with the number of reviews that get to the AAT under the CIRCA-DIRCA regime. Now, one of the differences between the regimes is that CIRCA-DIRCA decisions don't go to the Veterans Review Board. They go straight from the DVA to the AAT, whereas VEA and MERCA decisions can be appealed, speaking loosely, appealed to the Veterans Review Board for a merits review. Now, does the fact that the AAT gets so many more cases through the DIRCA system compared with the VRB, the other system, does that say something about the quality of the VRB's work?
No, I think it has nothing to do with that. Like it's a theoretical construct, but I think it can be disproved by the fact that until recently there was a very very, very active jurisprudence about the VEA and the AAT, and those decisions all went through the VRB. What has happened is that in the last couple of years, there's been very few VEA decisions at the AAT, and the reason for that was not the VRB. The reason for that is that the jurisprudence is pretty much settled, apart from the special rate pension and the SOPs. That they're not litigating anymore in the VEA area. So it's not to do with the VRB as such. It's actually about the legislation has settled down. Now with the MERCA and DERCA, I don't think the VRB features in that to any great degree. I think it's actually, litigation tends to be about who gets refused and how active they are in opposing that refusal of their claim. And what has happened in recent years, I think I've never been quite sure why the numbers have been so low in MERCA, but I think part of it might be my thesis that the incapacity provisions are so generous that nobody would actually be stupid enough to seek an appeal against it, because you can't go, you wouldn't appeal on an incapacity matter. I know there was one, but that was a very, very bad bit of drafting in the legislation where MERCA, it wasn't clear initially whether there was a minimum amount of compensation in the MERCA. And one of our strong litigants in this area brought a case to the AAT, then the federal court, and managed to establish that the national minimum wage does in fact form a minimum to MERCA incapacity compensation. Wasn't clear from the legislation, but by and large, there's less to litigate about in the MERCA, and in recent years, it is absolutely clear to me that the DVA has not been litigating against their clients in the same active manner as used to happen between, say, 1995 and 2016, 17. There's just been a change in the attitude of the department to contesting reviews, which has come about presumably because of political pressure. They're responding to the fact that everybody's unhappy with what's been happening, and part of that is to settle matters. I think there's still a lot of MERCA matters actually at the AAT, going to the AAT, but they never come out the end. They get settled in the case management phase. I haven't looked at the numbers exactly, but I believe there's still a healthy number of MERCA cases going into the AAT from the VRB, but they don't come out because they settle.
Professor Craik, is there anything you would add or detract from that discussion?
Can I just say something about the
Or
question
anything
you've
else,
just
yes.
asked? I think many of well, firstly, can I say that, like Peter, I was surprised that challenges to MERCA took so long to emerge, and they did, a surprising amount of time. Under the VEA, there were regular transitional provisions that covered quite complex issues, and I think, Council, you'd be aware of how technical transitional legislation can be, and much of the challenge that occurred were due to those transitional acts, but also there was a culture of challenging the VEA, which continued and I thought would be replicated when the MERCA came in. And I was surprised that we had to wait so long for jurisprudence to develop. Having said that, I agree with Peter that I don't think it's anything to do with the VRB. I think it's the nature of the legislation, and probably the fact that the department has become a lot more aware and has produced systems which benefit, I think, applicants. The streamlining and pass-through processes which have been introduced have certainly meant that many very common diseases are just accepted now, so there's no need for a challenge to occur. And the number of diseases which are being covered by those two schemes is increasing, so that's part of it. I think that figure that I saw in the Productivity Commission report, that something like 90% of cases or claims were accepted ultimately, at least in relation to one condition, indicates that increasing generosity. And there was one comment which surprised me, but perhaps explains a little bit why the more generous attitude is being, in effect preventing more challenges, and that is the fact that the officials are in fact interpreting a standard of proofs in a very generous way, so that these steps have certainly had a beneficial outcome in terms of litigation.
Do you, Professor Craig, consider that there's a good reason why the review process under Merca-Durka proceeds via the VRB and then, if need be, to the AAT and then, if need be, to the judiciary, and the Durka system cuts out the VRB?
No, I don't see any justification for it.
And would you abolish the VRB or insert the VRB into the Durka review system?
The VRB is another independent filtering process. I think to have an independent level filtering process is important when you've got a high volume. I think if the volume of applications goes down, the justification for the VRB also goes down. The same was true for the Social Security Appeals Tribunal, and I think it would also apply to the VRB, but it is dependent on the importance of that filtering process, which the intermediate merits review, independent and external merits review process does provide.
The government, I'll come to you in just a moment. I may as well do it now in case I forget. Mr. Sutherland.
No, go back onto Robin.
Well, I was going to broaden the discussion because in terms of the VRB perhaps becoming obsolete when the number of claims reduces, the government has recently announced a large increase in the ADF. And I don't have the details to hand, but you may have heard about it. Do you foresee a reduction in the number of claims in the next couple of decades?
As I said, I think it depends on a number of features to do with the improvement of the schemes and the improvement of the administration of the schemes, so that the two are correlated. If you have generous schemes, well administered, you're not going to have appeals, and therefore you probably don't need an intermediate merit review body. But if that doesn't come into effect, then I think the filtering process is valuable.
Mr. Sutherland.
Yeah, I remember what I wanted to say, that there was an amalgamation of all of the tribunals in Australia in 2015. The migration tribunals were put into the AAT, as was the Social Security Appeals Tribunal. Now, at that time, the VRB was specifically excluded from that amalgamation process because the veterans community wanted the VRB to continue to exist as an independent agency. But for that, it would have gone into the AAT as probably a Division 1, a Tier 1 of Veterans Review, just as the Social Security system now has a Child Support and Social Security Tier 1 division and then the General Division. The VRB still exists rather than being part of that AAT two-tier system, because the ex-service community were very adamant that it should continue to exist as a separate body.
Can I just say I agree with that analysis, but if the VRB intermediate role was rolled into the AAT, I suspect that there would still need to be a right of appeal within the AAT, Tier 1 and Tier 2, as Peter was just mentioning, to compensate. So you would still get some sort of filtration. One of the changes which has occurred since 2015 is that within the Social Security system, now at the first tier within the AAT, you'll have the decision being made by one person. When I was on the SSAT, we had often 4 and sometimes 5 people making the decision. And then at the appeal level, you'll have multiple people. So there have been trade-offs about the scheme, but a two-tier system was retained, largely for the volume issue within social security cases. And I think that a comparable decision or program would be advantageous in the veterans' jurisdiction. But I concur with Peter that there was a very strong push by the veterans community to prevent that happening, and the government listened.
Now, let's assume for the moment that the VRB in one form or another survives the next few years. One policy decision would be a choice between putting it as a division, as a branch of the AAT with an internal appeal mechanism, and another is to keep it where it is in the DVA, which is said to integrate it with DVA systems and make it more efficient, better access to information, quicker processing. For those or any other reasons, does either of you have an opinion on which might be the better model? You may not, but Mr. Sutherland.
Look, I think both can work, really. The Tier 1, Tier 2 Social Security appeals in the AAT, I think, has worked. I preferred the old SSAT, but you know, I think it's working as a Tier 1 and Tier 2 in the AAT. With the veterans area, look, the important thing is that first tier, whether it's a separate group called the Veterans Review Board or a Tier 1 in the AAT, it's really important that some of the characteristics of VRB review remain. For example, that there not be representation by the department, that the veteran applicant has the right to sort of speak in an informal manner with the reviewer. Or, you know, we don't want to overly formalise that first tier of review. I think there are things you can do to improve the VRB. They're already improving their case management. I think there has been significant improvements in case management at the VRB, assisted by legislative change in about 2016 or so, I think. There's obviously more improvement can happen. I think there has to be improvement also in the way that the department moves its cases to the VRB. I really think there's a failure that the DVA doesn't do a proper internal reconsideration. I think that's an important part of a review process. The department gets it right before it sends it off to an independent review panel. But we do need that VRB type approach, informal, not contested by the lawyers on both sides, which is happening in the AAT, but strong case management, settlement culture, all those things.
I'll ask the operator to bring up the first 3 dot points on page 0073. Just a piece of clarification, Mr. Sutherland. You'll see in the 3rd dot point, you'll see the Roman numerals. This is your opinion of what a review scheme might entail. The second one is review by the VRB. There are other points. I just meant to remind you of that as context. My real question is about the 1st dot point, where you say it may be desirable to accept that the review arrangements for each scheme could be different. Did you have any differences in mind that might be desirable?
Between the VA and the MERCA?
Yes, just in terms of the review mechanisms.
I think that it's hard to make changes at the VA. There's just a very entrenched culture around it, and that might inhibit achieving a best practice model, which is where we need to go forward with the MERCA. Like if we can bring the VA client group along with the changes, the improvements to the review system for the MERCA, great. But I wouldn't have the reform hang on it happening. Like if the VA needs to stay a little bit different, then it's a legacy scheme. I really see it as a legacy scheme, unfortunately with 60 years to run, but it's a legacy scheme.
Perhaps I could ask the operator to go over to the page, 0074, page 54 of your paper, Mr. Sutherland. We're under a new heading now, which is Scheme 1, the VEA, reducing the longevity of this residual scheme. Just a very short question. You'll see in the bottom half of the page 2 dot points. These are ideas for earlier closure of the scheme.
Yes.
We won't go into that. We won't have time to do more than read your paper, but I just have this question about the first dot point, which is to move the younger cohort across on a compulsory basis, largely because, as I apprehend it, most of them will be better off anyway. But could I ask this, do you see any merit in having such a move of the cohort on a compulsory basis, but with an opt-out provision? So if someone took the initiative to opt out?
Well, I think that's what is currently on offer. The Productivity Commission's recommendation was that it should be a voluntary transfer with all the carrots you can possibly put in. The thing is that when you do that, there will be a small residual group who won't, for whatever reason, won't move. Now, it might be because they will not be advantaged by the move, or it might be just they're comfortable with what they got. And that means to say, in the worst case scenario, you've got a cohort of 50 or 60 or 100 or 200 people left for the next, adding 20 or 30 years or 40 years to the life of the scheme, simply because they haven't moved. So that's why I'm saying at some point you possibly do a compulsory transfer. And the figure identified by the Productivity Commission, the age of 55, is one that I think that probably I suggested to them. By the time you get to somebody who's 65, the Mercer scheme is nowhere near as good as the VEA scheme. Like if your incapacity payments only last for another 2 years and stop at age 67, you're far better off on a lifetime pension, even though it's much less. I'm just worried about, doing something that leaves a very small cohort of people that extends the scheme for another 20 to 40 years. And this is the group, it's quite a large group, but it's the group that were some peacekeepers, but mainly it's Timor-Leste and the Second Gulf War, I think, are the group that I'm talking about. They're basically in their they have to be 40 now, I think, that group. Just if you count the years since 2004. So I'm just saying that if we're going to have we should have a transfer from Scheme 1 to Scheme 2. We mustn't allow people to go from Scheme 2 back to Scheme 1. That would be disaster. But perhaps we can foreshorten the legacy VEA scheme just by, as I said, looking at that group who will actually primarily benefit by the shift. Now, not all of them will see that as a benefit, but I see the benefit will be moving them into a better structure for rehabilitation and income support. Incapacity payments, rehabilitation, return to work are a better framework for a person who's 40 to 55 than a lifetime pension scheme. But by the time you get to, say, 62, 65, you wouldn't want to move. There's no advantage in going to Mercer except a lump sum payment for the permanent impairment, and you won't get that in the shift because you can't get double. There's real problems in this whole area, but that's just one of my thoughts. We could drop the longevity of the scheme by moving that Timor, Second Gulf War group into the Scheme 2, and I think they'd be happier there. Not all of them be better off, though. I think it's just impossible when you get into the business of everybody must be better off. You just can't do anything in the end.
Professor Craik, anything to add to that analysis?
I accept that analysis. Can I just say that education is a critical element of the change of attitude that may be needed on some of those recalcitrants, as Peter was describing a moment ago. And there are, as he said, and I agree, entrenched attitudes amongst many veterans. But in terms of longevity, if the demographics are in any indication, I think male longevity is up to about 83 years and women is about up to 85, and it may even be a bit older. But we don't like that gap for those people that Peter was talking about a moment ago.
The second point I made in the paper is about the widows, of course, and that's very much a personal hobby horse.
Well, we won't go there, but it was quite a striking historical narrative about the American Civil War.
Yes. And we have the same thing here, except that the 70-year-olds don't tend to marry 15-year-olds in Australia, but they do marry 30-year-olds.
Yeah. Just coming back to the the very largest policy, one of the very big policy choices is the trade-off between accrued rights for some against the deleterious effects of complexity for others. Perhaps one wouldn't criticise or be surprised that anybody would want to hang on to their existing rights. But is there a recognition that perhaps that is causing harm to others? And if there is that recognition, do those with the rights seem to give weight to the fact that the complexity of the system is causing serious harm to others? If perhaps Mr. Sutherland first, and then I'll go to...
I think individuals tend to have the prism of their own well-being. You know, it's all very well to think widely about society, but in the end, you have to look after yourself and your family, and I think that's just the way it is. For me, the real answer is that complexity is a problem, but it's not an irredeemable problem. You can actually solve it by having the department deal with the complexity, not the individual applicant or their voluntary advocate. You know, the scheme is horribly complex. We can improve it. But in the end, complexity is not necessarily a problem if the department, as they are now, has a single claim process. You put in your claim and say, what can I get? And the department tells you what they think you can get. You don't have to deal with which act it is that you're going under and making all those choices. You're told what they think is best for you. If you don't like it, then you appeal. And I think that's the way, one way you can deal with the complexity is you simply improve your administration and in particular, take the load off the individual claimant to make the right choice and have the right advocacy and have the department do it for them. And with a review system, because the department doesn't always get it right, obviously.
Can I just say, I was thinking about this issue about accrued rights. I wondered whether there might be a trade-off between acceptance generally of the reasonable hypothesis standard, which will obviously benefit a larger number of applicants, and loss of accrued rights. In other words, the Mercer system, which demands that the latest SOP be the one which is used. That might be something which could be solved, provided it was there was a lot of education and information about it.
Finally, with the time available, Professor Craik, were there additional comments? You'd prepared some comments at the beginning, which we defer to the end. Is there anything left? And I think there are some matters that you were minded to mention. Is there anything that you would wish to mention?
I confess that I focused very much on Chapter 8 of the Productivity Commission and the suggestions in that chapter for changes. In particular, in relation to the Repatriation Medical Authority and how it was going to be structured. There was a suggestion that the SMRC, the Specialist Medical Review Council, should be abolished. I checked the last couple of years' annual reports, and it appears that that body, the Specialist Medical Review Council, has not in fact had a case since October 2018. That's nearly 4 years ago. And before then, it was only hearing perhaps 2, maybe 5 at max appeals each year. Now, I've been a part-time member of tribunals for a long time. When you're a part-time member, unless you're used, you don't acquire the knowledge and the skills which make you a good and useful member. And that problem arises, I think, in relation to the Specialist Medical Review Council. They've got some 35 counsellors, according to the Productivity Commission, and many of those people will never be used, so they won't acquire the institutional knowledge, the understanding of the scheme, which is required to make effective decisions. So for all of those sorts of reasons, I do wonder about the value of the SMRC. If it were to be abolished, I think on fairness grounds, and probably because it would be required, some sort of review of an RMA decision, Repatriation Medical Authority decision, would still be important. the suggestion from the RMA itself was that there should be a couple of independent experts who would be consulted after an appeal and would make a recommendation to the RMA. Now, I'm a member of a body which operates in much that way. It's the Ad Standards Australia, which deals with complaints about advertising, public advertising. And there are two national reviewers, of whom I'm one, and we are allowed to look at the original evidence. We're allowed to look at new evidence which wasn't available, and we make recommendations back to the panel which made the original decision. Now, that scheme works quite well, but it depends very much on the cogency of the arguments that we can produce to persuade the panel to change its mind. So the RMA suggestion could work in that regard. But also, I noted in that context, and this has to do with the frequency of use of even those two independent panel members and their skill level and knowledge level, and that is that if there were only 2 to 5 cases a year, the same problem would still arise. So it seemed to me that you could, in fact, use them for another purpose. As you're probably aware, Council, there is a sort of pseudo-SOP process under which, both under MERCA, under Section 340, or under Section 180A of the VEA, the respective commissions can actually take the initiative in circumstances when the RMA has either not made a SOP or has refused to make a SOP. And in those circumstances, if for whatever reason the Commission thinks that there is value in having a SOP, they can make one. Now, the legislation stops at that point, and it doesn't in fact indicate who's to do the analysis required for sound medical scientific evidence. And it seemed to me that if we had a little cadre of experts, one of whom would be an epidemiologist, and perhaps 3 or 4 who cover the expertise needed for the majority of claims on which review is sought or an appeal is sought of the RMA SOPs, that body could be used by the commissions for that function as well, which could be activated to a greater extent. I think there are something like 92% of the sort of diseases which are claimed, which are covered by SOPs, but there's still a little gap there. So those provisions, 180A and 340, could be used a bit more proactively. I think Peter did some research and found only one occasion on which either provision had ever been activated. So it hasn't actually been used, or they haven't been used. But if you had a little group of experts covering most of the diseases, who could give an independent recommendatory opinion back to the RMA, and depending on their skill set, the amount of information they had, it might well persuade the RMA to change its mind or to make a provision, then you've got use of those people, a build-up of knowledge and experience, and in fact, it could work quite effectively. So that was one suggestion that I wanted to make.
Thank you very much. Mr. Sutherland, any response before I allow others to have a go at you?
In the paper, I haven't addressed the SOPS issues really at all. The question of Section 180 and Section 340 is an interesting one, because as far as I know, it hasn't been used, 340. And I have a memory, and it's only a memory, that Section 180A was used to resolve some Agent Orange issues back in the 1980s, once, I think. I haven't been able to find anything to confirm that, but it hasn't been used, but it is an interesting power, because it gives you quite apart from the use that Robin's talking about, that provision could allow you to deal with the fact that sometimes the SOPs are not regarded as being flexible enough. You could possibly put in a process like that that allows the Commission in a specific case, or specific condition probably more than a case, to make its own, set its own opinion on the basis of the medical evidence that it itself gains. It's just a possibility. I've always, in relation to SOPs, and I haven't put this in the paper, my feeling has always been that the SOPs are a very good process for an acceptor contention. In other words, the SOPs are a good way of accepting a claim, but I believe that if you want to reject a claim based on a SOP, then probably there should be an opportunity to adduce comprehensive medico-legal evidence, medico-scientific evidence, which you can't do at the present. Basically, if you don't fit into a SOP, you're gone. And I would prefer to see a situation where there is some room for an applicant to put up their own scientific medico evidence in a particular case. And it would be pretty rare, I think, because the SOPs mostly do cover the field and cover it appropriately. But I didn't really look at the SOPs issue in my paper.
Nevertheless, thank you for your evidence, both of you. Commissioners, those are the questions that I've got for this panel today.
Thank you, Mr. Singleton. Commissioner Brown?
Thank you very much. I have to say this is not my field, so I'm probably going to keep my questions and comments to a minimum. I have a couple of questions. One is, early on in the discussion, there was the distinction or discussion about the distinction between operational and warlike operations versus non-warlike or kind of on base type claims, injuries that might occur on base. My understanding is there's different sorts of operations, some of which might be overseas and some of which might be in Australia, and some are warlike and some are peacekeeping and some are humanitarian or what have you.
Welcome to the complex world of military compensation. It is different between the MERCA and the VEA. That's starting number one. The MERCA terminology, where I go, because I think that's the scheme we have now, that's where we're going. In the MERCA, you have a thing called warlike service and a thing called non-warlike service, both of which are regarded as operational active, what used to be called active service under the Repatriation Act. Separately from that, there's a thing called peacetime service. And then collectively, all three become, I think it's defence service. So the distinction is between peace-like and, on the other hand, warlike and non-warlike. That's the terminology. The difference in warlike and non-warlike, I think, is really the terms of engagement. When we send people into Afghanistan, we're expecting them to have to engage actively with the enemy, and that was warlike. There are other engagements where you're not expecting that active engagement, but there is a danger, a risk arises. I think the Solomons might be an example. The Solomons would probably be regarded as non-warlike service, but nevertheless it is active operational service. The VEA is a little bit more complex. I just don't want to go into it, it's just too complex. But there is that difference between peacetime and then warlike and non-warlike. And I think, personally, I think there is a valid distinction. I've said it. I think there is something about being sent into these environments overseas where you cannot, as an individual, you cannot manage your personal risk without compromising your colleagues and incurring disciplinary offences.
Okay, thank you.
Can I just say that
Yes.
even in the VEA, the non-warlike type service is peacekeeping service, so that there is often a risk involved. So it's the risk level of both wartime and non-warlike service generally overseas, which is involved, as compared with service domestically. Given the use of the Defence Force under Defence Act Part 3111, I think it is, in domestic emergencies, I do wonder about that distinction, but that's an aside. But as Peter was saying, the language in MERCA and in the VEA are slightly different. He talked about what did you say
Active-
it was?
active
Service. In the VA, it's eligible service. So yes, the terminology does make it very confusing.
Indeed, and I think for many people, the distinctions are difficult. Could I ask another question, Professor Crike? You spoke about the opportunity for administrative changes to have significant impact even now, but you said that they would come at a cost that may well be offset by the gains in terms of overall health and well-being. But do you have a sense of what the quantum of that cost that you're talking about and kind of what period it might take to be balanced out?
I don't have any costings, nor did the Productivity Commission, sadly, and it would require considerable work. And I noticed with interest in the Productivity Commission report, they said doing some of that comparative work will be quite difficult because quite a few of the entitlements have been, or at least there have been interactions between VA and Services Australia now, which mean that statistics prior to 2017 are the only ones that we've got, and the more recent statistics aren't comparable. So there are some statistical issues about how you calculate a comparative financial benefit from the potential for administrative change. But that's just a matter which I'm sure can be surmounted with some assistance from within the public sector.
Okay. And my probably last question, I always say my last question, then I find another one, but literally my head hurts sitting here listening to the discussion. It's just mind-boggling, the complexity that we're dealing with. Does anyone do it better in another country? Is there something else that we could look at that would deliver a comparable kind of outcome without the complexity that we're dealing with?
I mean, the Australian scheme has been seen as the lodestar, the best scheme and the most beneficial. Now, having said that, I did notice in the Productivity Commission report, it referred to a UK system in which, in terms of post-service, diseases claimed after a serviceman had left the ADF, reverted from a more beneficial approach to an ordinary civilian approach. After, in the UK, it's 7 years. Now, Australia could adopt something like that, which might reduce some of the cost for claims which are made after a certain amount of time. Those claims would therefore justify the less beneficial response, because some of those injuries or effects which led to diseases might in fact at that stage be due to aging and domestic circumstances rather than service. And that trade-off, I think, is a fair one. Australia could maintain its beneficial star status by having the period of time something like 10 years rather than 7 years, but that scheme, I think, has some advantage. But overall, the Australian scheme, even although it's perhaps made much more complex by the 3 acts that we've got, is still one of the more beneficial, more generous, and therefore less likely politically to be changed than other countries, other comparable Western countries.
Thank you.
Thank you. Commissioner Douglas.
Thank you. And thank you generally for what's been a very informative discussion for me too. Mr. Sutherland, you spoke at one stage about the unique quality of overseas active service, and then I think both of you spoke about the financial incentives to deploy on active duty. From what I've heard from some of the people we've seen already, one of the major incentives to deploy overseas is not financial, but it's because it's what you're trained to do, and it's a fulfilment of your ambition as somebody in the military. Do you want to comment on that?
Well, that is very important, that second part, yes. But the financial incentives are actually quite strong. And in the olden days, more not so much recently, but the availability of Defence Service Home was a very strong attractant to overseas service. I don't think that exists anymore. But, 20 years ago, that was one of the bigger, the fact that your overseas service would give you access to home ownership.
Yes, I understand that.
So I think that it's both. There is definitely that issue of what you've learned to do and applying your skills, and of course the group of people you're with. That you're in a unit and you train as a unit, and there's all those social things that are very important. But I think the remuneration is important. But I was making the point more that I think that the compensation issue is simply not in the front of the mind until you're injured. I went into a barracks, this SAS barracks in Perth, Canberra barracks I think it is, and most of the people in the room there wanted to talk compensation because all of them had been injured. Some of them had up to 6, at that point, 2011, they had 6 or 7 deployments, and all of them were carrying injuries, and they wanted to talk about compensation. But we went into a barracks in Townsville, people about, I think possibly on the rotation to go overseas. None of them had even a question. They weren't interested. They really thought that the army would look after them. That was their belief.
Yes. My next question related to a recommendation of yours, Mr. Sutherland, again about assessment of disability on discharge or around transition. One of the features I've observed from quite a few people who've spoken to us is that often during service, people in the military wish to hide or obscure particularly mental disabilities or mental effects on them of their service, and even some physical disabilities too, I suppose, ones that aren't so readily obvious because of fear for what that knowledge might be used for in affecting their future service and ability to be promoted. How would that affect that assessment at that stage, do you think?
It's not a fear, it's a reality.
Yes.
People are, it's undoubted that people in the ADF suffer by disclosing their injury. Hopefully that's a culture that can be changed, but it's been a very powerful thing in the past.
Ideally, it should be changed because often people, especially with some disorders, benefit most from early treatment.
Absolutely. I think the point is that the history of military service in Australia has been that you make all your claims the day you discharge or the next day. You're literally fit for overseas service one day, your discharge papers arrive, and the next day you're going for permanent and total disability TPI rate. And that means to say that the injuries were probably there, they were just not disclosed. And then there is once you leave...
if they haven't been disclosed, it might be used as a weapon against you to say...
Well, it is. That's the way it has been used.
It doesn't exist.
So the time to do it is in that lead-up period to discharge. In other words, people know when they're going to discharge if it's a voluntary discharge, sometimes an administrative discharge or invalidity one, there's no choice. But even with those, I think you can hold the discharge up, if the person allows you to, until you've determined, at least done the medical examinations that are necessary, and preferably keep them on service pay until you've processed their claim, or at least their basic claim. Otherwise, you can use the veterans' payment at present. But look, even now, I think they do a hearing test on discharge, which is really useful and important because it means that you can tell what hearing loss there was during service. And once you leave, then of course, if it's an occupational hearing loss, then it's not going to get any worse the moment you stop going to the rifle range. So having an end point of your hearing test at the end on the last day gives you a baseline for your hearing loss during service. And that just needs to be, that concept needs to be much wider. But mental health is such a difficult issue because people go into service with, of course, pre-existing mental problems.
Yes.
Which may manifest during service, it may not be, may be triggered, or it may actually manifest for completely private reasons after discharge. You know, there's all sorts of, human beings are different. But I'm just saying that let's do what we can just before that point of discharge, and importantly, start transition really early so that you're moving into that end point in a sensible, constructive way.
Thanks. Professor, you...
I think the discussion earlier with Council about the advantages of overseas service has to be taken strongly into account. To do overseas service, with all the benefits that that brings, you have to be at a certain medical classification level, and that's tested. And so you just don't report during service what injuries you might have, because you really want to serve overseas. You want to use the skills that you've acquired during your training in the Defence Force. It's seen that those skills are best used overseas, and you get the financial benefits, so you just don't report.
And which can be very significant, the financial benefits, as you've said. Because in some circumstances you can get tax-free allowances, I gather.
Oh, yeah.
Yep.
Yes. The final area I wanted to explore a bit was this idea of having the two parallel acts, a merged DERCA and MERCA and a continuing VEA. I'm speaking at a high level of generality now, which illustrates my complete ignorance of this area of the law. I'm sure, unfortunately for me, but it's one I haven't had to look at until recently. Why couldn't you have a single act with, say, a single body of definitions and of procedures, but retain the two main streams in separate divisions of the Act?
It sounds to me a bit like the Federal Circuit and Family Court of Australia. It's an amalgamation in name only.
Or a camel designed by...
Or a camel. I think probably keeping the VEA distinct in Scheme 1 is a good idea because it allows you to grandfather and continue practices and approaches to military compensation which are not contemporary, but will create great pain if you actually try to change them. And so I would stay with two schemes. Of course you can create one scheme. We could do it, we just say MERCA covers everything, but it's a bit like at the moment, the DERCA is actually 3 acts. It's one act, but it also incorporates the 1930 Act and the 1971 Act, and your liability and your entitlements are completely different in some areas as to when you were injured. You know, you can't get compensation, impairment compensation for a back injury if it happened before 1 December 1988. There's still 3 acts. It's one act, but transitional provisions, grandfathering, all of that stuff just means, say, you call it one act and you've still got 2 to 6, or we've got 6 or 7 at the moment. What I think we have got is the possibility of moving the DERCA into the MERCA in an intelligent way. You know, we've broken the link between DERCA and the Comcare system, the Commonwealth Employees Compensation. It's now moved, it's now DERCA, it's under the policy control of the Defence Portfolio. It gives us the opportunity over time to move those DERCA people into MERCA, essentially you could probably even do it on a no loss, in no disadvantage basis over time. So I think we can actually get to 2 schemes. I think if we tried to get to the one big scheme based on MERCA, you would end up with essentially the VEA would still be there in all its grandeur, it'd just be called MERCA.
Is that because the VEA's procedural...
No, I think it's just a completely different approach. You know, the lifetime pension approach with no lump sums, no compensation for impairment, a fairly low rate of pay.
I understand that, but why couldn't that be one division of an Act and MERCA, DERCA, another division of the Act?
Well, you can definitely draft it that way. I just think it will still be 2 schemes inside the one Act.
I'm not denying that.
Oh yeah, absolutely. I just think that we're going to have to keep a carve out of the large you know, the 250,000 people on the VEA, basically.
I understand that,
Yeah.
but I'm just wondering whether there might be some procedural or
Oh.
other advantages of having, say, one application and then divide it into...
Yeah, possibly. But we've already got one department now, which is a good start.
Yes.
You know, one policy department. So I think a lot of the VEA stuff can be brought into line with MERCA really fast. A lot of the administrative stuff should be the same. I think we can
Professor,
do that pretty
do you have any
quickly.
views about that?
I agree with that, and I think it's a good time to just park the VEA. The jurisprudence has virtually died out, as Peter was saying, except for SOPs and special rate, but even in special rate areas, the amount of challenges have gone down considerably. So in lots of ways, it's settled jurisprudence. Don't play around with it. Leave it as it is and, work on combining MERCA and DERCA and harmonising the provisions, for example, in relation to allowances between the 2 or 3 acts and applying the SOPs to DERCA as well as to MERCA. These are all steps which can be taken to simplify and harmonise the legislation in a way which will improve administration and speed it up and reduce the likelihood of the sort of deaths which can occur from sheer frustration.
Commissioner, if I could say that every time you create a new act, you create the most complex and appalling sets of transitional provisions and litigation for the next 10 to 15 years. And that's what I'd be scared of if we actually moved the VEA into being a division of the MERCA in some way. We would just create a nightmare, a further nightmare of transitional and application provisions.
That's why I said I was speaking at a very high level of generality. Thank you.
Thank you.
Thank you both. Certainly, this is one of the most important areas that this Commission is examining, and there's ample evidence that has led to much angst and, in fact, suicidality, obviously, so it is very important. I just have a couple of issues I wanted to raise with you. I just want to confirm that I've got it right in my mind. Are you both agreeing with the notion that it would be far more preferable for people to lodge and perhaps have assessed and finalised or close to finalisation all their claims in various injuries and what have you before they discharge or transition out of the military? We've heard a lot of evidence about people who feel they were not coerced, but certainly pushed out the door, basically, before their claims were even lodged, which caused hardship down the track.
I think that probably the incapacity claim needs to be determined before discharge. Permanent impairment, I think, can take time. That's a lump sum payment under MERCA. It can take more significant medical evidence and so on. My main concern is that the person has an income support in place for when they leave, and also their rehabilitation is absolutely rock solid in place. And medical treatment. So I think that's where we need to have the transition sewn up by discharge. Permanent impairment and some of the other issues can be a bit longer term.
And I think there are also the issues of the latency period for some diseases, the mental health issues, the mesothelioma that I mentioned, heart conditions, high blood pressure, all of these are likely to manifest and become apparent later on rather than at the time you're ready to discharge.
Thank you. Certainly the two areas you mentioned, Mr. Sutherland, are the ones that seem to cause the most grief. That's the gap in any sort of benefits and the fact that treatment is either disrupted or non-existent before they discharge and then lodge the claims later on. For both of you, are you aware of, we have been informed that in the United Kingdom, there is no Department of Veteran Affairs. The Department of Defence accepts responsibility for individuals the whole of life, if you like, from when they join until later on. At the same time, all government departments are urged and perhaps compelled to do what they can to support the various veterans' needs. Are you aware of that model, and are you in a position to comment on whether that's working or not?
I can't comment on the English model at all.
I'm not aware of it.
I can comment, though, that We've now got state departments of Veterans Affairs.
We have.
Most states now. We've got one in the Territory here, for example.
All of them, in fact, have one.
I think there was a problem when the military compensation was inside defence. When the old days when the military compensation and rehabilitation service was administering the then circa. Defence doesn't have a priority for the policy of military compensation. It's not in their heads, really. They're getting towards, I think they are getting better about transition and workplace health and safety, and that's definitely their business. Whether care and support of people who have discharged is naturally part of the Department of Defence responsibility, don't know. But DVA exists because the service community has been violently opposed to any suggestion of merging it into defence. It's in the defence portfolio, which is a good start. Even has the same minister now sometimes, with the personnel side of defence has been the same minister as the DVA for most of the past 20 years, which is interesting when they disagree. We've had one case where the defence and DVA didn't agree and they had the same minister trying to resolve it. But that was fun.
Anything you want to add?
I don't have much more to add to that, except to say that the philosophy of both agencies are different. One is on rehabilitation and on health and well-being, and the other one is on health and service and competency. So that different focus affects the way they deal with people who have problems.
Thank you. One final point. Professor, you mentioned a bit earlier that the Australian system or framework is seen as beneficial, the gold standard, perhaps my words, not yours. Is that something that is discussed sort of in the academic space and in professional space, or are there any papers that you may point us to that does a comparison, has a comparison of all the various systems and reaches that conclusion?
Forgive me, but I'll ask Peter to just translate.
Are you aware of any papers that would justify that position about Australia being the gold standard? Have you seen anybody doing work on it? I don't think I have.
Are there papers? There's certainly articles which acknowledge it. And there are certainly cases which acknowledge it as well, that it's a beneficial system. And those cases are referred to, and we'll do a little bit of selling in our book under beneficial treatment. Having said that, there is something of a diminution in the way that beneficiality is interpreted by courts over time. And there's probably been a diminishing recognition of beneficiality over the period, but it is still there, and it is still a philosophy which is strongly supported by the veteran community.
There is not a lot of writing in veterans' entitlements and military compensation in Australia. And that's where anybody doing a comparative study would be writing. The American system seems pretty terrible from what I've seen of it, but I'm not really aware of writing in that field. No, we haven't written it.
Thank you, and thanks for interpreting, Mr. Sutherland. I might need to call on you again.
Can I ask just one last question?
Penny, please.
We have had suggested to us on a couple of occasions that it should be looked at giving everyone who leaves defence a gold card as a way of doing away with some of the necessity for claims and proof and medical specialist appointments and such like. Do you have a view about that?
What was that?
I'll answer and then you think about it. Look, I've got really strong views on that. I think the gold card is perhaps an overused mechanism already, and to make it universal for everybody who's ever worn a uniform for a day or more, I don't think it would. I don't think the community could afford it in the end. Like, it would be good if the whole community can provide that level of medical treatment for everybody. The gold card, I think, probably is quite expensive. For example, the cost when we introduced the gold card for everybody in the Second World War who was who had served overseas. It was really quite staggering because it was hundreds and thousands of people. The Productivity Commission made a definite recommendation to restrict any future use of the gold card, and the government immediately rejected that. That's political, but I think the white card is an excellent mechanism, but the gold card is a difficult mechanism unless it would be better if it was perhaps time limited. But basically at the moment, a gold card means to say that a widow who's in their 20s will still have essentially very universal medical treatment in 100 years, in 80 years or 60 years' time. It's got a very tenuous link with the actual medical service that gave rise to that necessity for medical treatment. And with individuals, the VEA, the older veterans group, it's primarily about diseases of ageing. Now, I've got no problems with good treatment of that group, and they're a very large group, but I'm not sure we should be expanding that universal entitlement, because if we expanded it to encompass everybody who ever put on a uniform for more than a day in Australia, I doubt that our community, one, could afford it, and two, I think there would be a community reaction to that. And I think it would detract from those people who really need that level of assistance, ultimately. It would take 5 or 10, 15 years, but I know that Senator Lambie put a proposal essentially of that nature into the Parliament before the current one. The bill lapsed because it never was brought on. I'd be interested to see whether Senator Lambie thinks that's the best policy now, because she has matured in her, well, sorry, I shouldn't be talking politically, should I? But it's a difficult issue because the gold card is an effective mechanism for a group of people who need medical assistance. It's financially effective, and it's also socially effective. It gets away from the mendicant. I need, you actually got an entitlement. That's good. But how widely you draw that entitlement has to be in the issue. And it's not wide in the MERCA. The MERCA has quite specific grounds on which you get a gold card, and the MERCA constraints, I think, are completely appropriate.
I think the gold card is one of those anachronisms in the VA, which are one of the reasons why many people do overseas service, and that's what they're looking for. They're looking for a gold card for themselves and their families. It is overly generous, but I noticed with interest that after the Productivity Commission report, the government rejected any abolition of the gold card, and that's a measure, I guess, of the political detriment that might be caused by attempting to abolish it.
Thank you very much.
Thank you. Mr. Fordham, is there anything you wanted to raise?
No, thank you.
Mr. Singleton, any matters arising?
Might the witnesses be excused?
Yes, you're excused from your notice to appear today. And thank you again for your evidence. It is a very complex area, and you've done your best to sort of dumb it down for all of us, I think, and we're grateful for that. Thank you. If there's nothing further, we'll adjourn till tomorrow morning, 9 a.m. I understand, not 10. Yep.
All rise.
Thank you.
The Royal Commission will now adjourn until 6th of April at 9 a.m.